For reasons mentioned in the judgment, the impugned notification dated 9/9/2021 issued by the Government of Nagaland Higher and Technical Education Department is found to be arbitrary and violative of the fundamental rights of the petitioner guaranteed to her under Article 14 of the Constitution of India as regards to its application for selection and nomination of candidates against central pool of MBBS seats for academic year 2025-26. Accordingly, to that extent, the impugned notification is set aside and the writ petition number 138/2025 is allowed to. In writ petition number 134/2025, for reasons mentioned in the judgment, the petitioner is found entitled to be selected for nomination of a seat in MBBS course against central pool for the academic year 25-26. The respondent number 3 is hereby directed to issue a modified merit list of these selected and nominated candidates and offer to her the seat which has been kept vacant in pursuant to the directions of this court. These writ petitions are accordingly disposed of.
Lordship, considering the time factor, tomorrow is Independence Day, day after tomorrow is a non-working Saturday, and then 17 is the Sunday. So 18 is the last day of admission. So my prayer is, Lordship, if the registry is directed to furnish the CDC at the earliest, urgently, we will take urgent steps for furnishing a copy of the
some
order.
Corrections are there.
Yes.
It will be uploaded at 2.
Lordship.
At 2 p.m.
But at the same time, if the Government Council is directed to inform the concerned department to do the needful in view of the order passed by the Honorable Court. I think that may save the situation. Otherwise, again, more complications may be created if there is delay.
Whether this 18th can be extended.
I don't think it can be extended, Lordship, because the seat of MBBS is very precious. So once they lapse that period, then it will go to another candidate. The
Okay.
government will take up the candidate seat.
Which government?
The central,
Or central?
because we have to return back to the central.
Yeah, you have to intimate
Yes, we have to intimate.
after 18.
Mm.
Okay, I'll mention in the judgment itself to that extent what is to be done.
Lordship, and at the same time, if a direction is issued to upload it at the earliest, so that we can also upload it the copy,
It will be uploaded
At-
at 2.
Lordship. And I would like to place on record considering the urgency in the case, the effort Lordship has given maximum effort for expeditious disposal of this case, Lordship. So I will tell my client to take a lesson on the urgency of the matter. If one day she does MBBS and take care of the patients, how important it is to save the life of a person. Those things we should emulate the concern. So I would like to express my gratitude to your lordships for tremendous effort for expeditious disposal.
Lawyers do not
Expeditious disposal of the
normally
case.
show such concerns when they get a favorable order. They have to remain neutral. Okay, any mentioning?
For expeditious disposal only, I'm referring that. Much obliged.
May I please, my lord? Lord, I may be allowed to move that motion. There's an urgency to stay the orders of the DB. Because, so if I may be allowed to make a unlisted motion. Petition has only been filed yesterday and it's been numbered. So I can call up at the end of the admission
At 2,
at two.
we'll take it up at 2.
Lordship. Much obliged.
May I please, Lordship? Lordship, may I mention item number 9, Lordship? I'm for private respondent number 4. Lordship, kindly allow me 2 weeks time to file my affidavit.
Heard, Mr. What is your name?
James Newman.
James. Item number 9.
Yes, Lordship.
You are for respondent.
Respondent number 4, private respondent.
You have informed the counsel for the,
Yes, Lordship, through telephonic.
okay. Who see James Neumai, learned counsel for the private respondent, who seeks 2 weeks time for filing affidavit in opposition in this case. He submits that he has informed learned counsel for the petitioner regarding his prayer for seeking time, and who has no objection to his prayer. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
Much moved.
Please, Your Lordship, I beg to mention item 11. Your Lordship, my senior has some personal difficulties today. So if the matter may come up after a week,
Heard, Miss
and solo.
in solo,
Yes, Your Lordship.
learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of her senior, who is the conducting counsel for the petitioner. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after
1 week, Your Lordship.
a week,
Yes, Your Lordship.
on
I
a,
beg, yes, Your Lordship.
on a date to be fixed by registry.
I beg to mention item 12 as well, Your Lordship.
Yes,
Can you grant us 3 weeks time to file our objection to the IA?
I has been filed by Union of India. No. You are counsel for?
I'm counsel for respondent number 4, the private respondent.
I'm for the petitioner.
Heard, Mr. What is your name? Petitioner's name? Income Jamir.
For applicant,
What's your name?
Peter Rana, on behalf of Income Sumer.
So write his name. Submitting on behalf of Mr. Income Jamir. Also heard Ms. N. Solo, learned counsel for the private respondent, who seeks private respondent number
4,
4,
respondent 4.
who seeks
2 weeks time.
2 weeks time to file their objection against the interlocutory application filed by the petitioner. Also heard Ms. Livika
For the state, Your Lordship, I am also yet to receive instruction, Your Lordship.
for the state respondents, who also seek some time, as she has not yet received instructions in this case. Considering the submissions made by learned counsel for the parties, let this matter be listed after 2 weeks,
3 weeks.
3 weeks.
Much obliged.
Your Lordship, may I be pleased to mention item number 17 and 17, 18 and 19. Your Lordship, there is a similar case which has been pending before the division bench, Your Lordship. So let this matter be, we are awaiting the outcome. So let the matter come up after 4 weeks, Your Lordship.
Heard Mr. Isinlo,
No, Lordship.
Isinlo him, learned counsel for the petitioner. Also heard Ms. Livika, learned government counsel, who submits that a matter similar to the present writ petitions is pending before the division bench of this court. And she submits that it would be appropriate to wait for the outcome of the said matter before proceeding in this writ petition, and hence prays for an adjournment. The prayer is not opposed to by learned counsel for the petitioner, hence same is allowed. Let this case be listed after 4 weeks.
Oblige.
Lordship, I also beg to mention item 20, Your Lordship. It is supposed to take up today, Your Lordship, but due to some health reasons, Your Lordship, I could not able to fully consider it on my file. So, Your Lordship, if the matter can come up Tuesday, Your Lordship, next Tuesday, 19th.
Last occasion, my lord, it was fixed under prayer of my learned friend.
Yes, Your Lordship.
So she's
As a fixed item, but then today the ground of mentioning is on the health ground. And that I have no objection, but I would pray that let this matter be come up as a first item in the hearing list on Tuesday,
Yeah, no,
as suggested by
Tuesday.
my learned friend, Lord,
On Tuesday.
as a fixed item.
heard Mr. C.T. Zamir, learned senior counsel, appearing for the petitioner. Also heard Ms. Livika, learned counsel for the petition, learned government counsel appearing for the state respondent, who submits that due to health reasons, she could not go through the brief properly
Yes, sir.
and seeks some time.
If it can come up on Tuesday.
Prays for listing this matter on Tuesday, that is
19th.
19th of August, to which learned senior counsel for the petitioner makes no objection. Hence the prayer is allowed. Let this matter be listed as first item under hearing column on 19th August 2025.
Much obliged.
As a fixed item.
I have mentioned first item.
Sometimes other preferences are also made, that's why Lordship, I did charity that. Obliged.
Please, Your Lordship. Lordship, I beg to mention item 9. I pray for 3 weeks to file my affidavit in opposition. Not mentioned.
Item 9. 9 has been mentioned already.
Okay, Lordship. Then Lordship, may I mention item 14 on behalf of SCHA, Government Advocate. We are yet to receive instructions, so we pray for 3 weeks, Your Lordship.
Heard Mr. N. What's your name? Longkumar?
M. Longkumar.
M. Longkumar. Learned Council appearing for
State.
appearing for the state respondents and seeks 3 weeks
3
time
weeks
for filing affidavit in opposition
to receive instructions.
to receive instructions in the case. The learned counsel for the petitioner does not oppose the prayer. Hence, same is allowed. Let this matter be listed after 3 weeks.
Yes. Your Lordship, I have a similar
Lordship.
prayer for item 15.
Item number 15.
Yes.
Same order, only the counsel for the petitioner name would be different. What is your name?
Mathoy.
Mithoi. Counsels for the petitioner name would be different. Otherwise, same order as earlier order.
Oblige, Your Lordship.
May it please, my lord. Lordship, I may be allowed to make a mention for item 3, 4, 6, 7, and 8. These are similar matters, Lordship. A similar matter is also pending before the division bench. Writ appeals 3 and 4 of 2025, my lord. So if these matters can kindly come up after 4 weeks, my lord. Meantime, I may be allowed to file my reply.
Yes. No objection.
3, 4, 6, 7, and 8.
Lordship, I'm appearing in 4, 6, and 7 for AG. In fact, we have nothing to say as far as the petitioner's case is concerned.
Okay, heard Mr. Senti Anger, learned counsel for the petitioner. Also heard Ms. AIME, learned government counsel, appearing for the state respondent, and Mr. N. Muzai in item number 4,
6 and 7.
4, 6, and 7. It is submitted by learned counsel for the petitioner that a similar matter, that is writ appeal number
3 and 4 of 2025.
3 and 4 of 2025, in which is pending before the division bench of this court. Hence, he submits that it would be appropriate to await for the
My lord.
outcome of the said writ appeals, and therefore he seeks 4 weeks time for filing affidavit in reply.
My lord.
The prayer is allowed. Let this matter be listed after 4 weeks.
Deeply obliged, my lord. Pleasure.
Your Lordship, I beg to mention item number 13. Here state is yet to file affidavit, Your Lordship, so kindly grant me 4 weeks' time. I'm yet to receive the parawise comments. 9.
Heard Mr. Toshi O. Longkumar, learned counsel for the petitioner. Also heard Ms. A. Aimi, learned government counsel, who submits that she is yet to receive the parawise comment from the concerned government department, and therefore seeks 4
4 weeks.
weeks time for filing affidavit in opposition.
My lord,
The prayer
4
is-
weeks might be too long, 3 weeks at least. The matter pertains to termination. And then now the petitioner has nothing and he has a family to feed. So, and at least an endeavor should be made by the state respondents to expedite the proceedings, Lordship.
What is the matter?
The matter is with regard to termination of the services of the petitioner. The petitioner was terminated
When?
last year, Lordship. And now he doesn't have anything, Lordship, and a family to feed as well. So with matters with regard to this, maybe an
Yes,
endeavor
Miss
should be
Aim.
made. by
Your
the
Lordship, an
state
endeavor will be
respondents.
made, Your Lordship, but I'm yet to receive the instructions. I've written to the department also.
Okay,
Your Lordship.
we are fixing it after 3 weeks. You try.
Okay, Lordship.
Let this matter be listed after.
After 4 weeks, Your Lordship. Let it be fixed after 4 weeks.
Okay, after 4 weeks. 4 weeks.
Yes, Your Lordship. Your Lordship, item number 16 also, a similar prayer. Here, I'm yet to receive the parawise comments.
Same order. Name of the petitioner, Mika H. I. You have any objection?
No, Lordship.
No objection. After 4 weeks.
Yes, Lordship. Much obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 2, Lordship. Lordship, if this matter can come up after 1 week, Lordship.
After?
To 1 week, Lordship.
You have informed the Central Government Council.
In fact, state respondent, I'm not sick.
You inform.
Lordship.
Heard Ms. Mika H.I., Learned Counsel for the petitioner who seeks. Why are you seeking adjournment?
Lordship, here the main counsel is taking care of this matter is in disposal, Lordship.
Who seeks an adjournment on the ground that the counsel, conducting counsel for the petitioner is indisposed. She also submits that she will inform regarding her prayer for adjournment to the London Central Government Council as well as government advocate. Considering the submissions made by London Council, the prayer is allowed. Let this matter be listed after 2 weeks. Show the presence of Mr. Yangarwati. Cut that line. 2 weeks, after 2 weeks.
In fact, 1 week, Lordship, if it's possible, Lordship.
1 week, after a week. Okay.
Much obliged, Lordship.
For motion, item number 1.
May it please, my lords, I'm appearing through video conferencing. Am I audible to my lord?
Yes. What is your name?
My lord Arindam Barua. I appear from Gauhati.
Yes.
My lord, this is a writ petition where the client has impugned the termination letter and the forfeiture letter which is issued by the NFR, Northeast Frontier Railway. And this arises out of a tender which is awarded to my client for picking up garbage from the Dimapur railway station. Now, my lord, as an officer of the court, I have to be fair that there has been some delay in approaching my lords in this matter.
Not some, a huge delay.
Yes, my lord. Yes, I'm fair on that, my lord, because it matters to the year 2014.
Yes, Mr. Yangarwati.
My lord.
You are appearing in this case. You have received notice.
Which item?
Item number 1.
Motion 1.
Motion 1.
Your name is a party?
Yes. Your name is shown in the constitution. Yes.
My junior must have accepted. My junior must have accepted. Well, take care.
Okay. Yes, what is to be done? Yes, Mr. Burra.
My lord, at the latest, we had issued them a legal notice when all our correspondences failed. Again, my lord, to be fair, they had sent us some notices and which we should have diligently replied, which unfortunately the client did not. However, my lord, the point is that the manner in which the notices were issued, that smacked of malified, my lord, because even...
Okay, we are issuing notice, though you have a very weak case.
My lord, I'll be very obliged, my lord.
Heard Mr. A. Burra, Learned Counsel for the petitioner. Also heard Mr. Yangarwati, Learned Central Government Council. Issue notice. Stop. Since Mr. Yangarwati, Learned Standing Council, Learned Central Government Council, has appeared for respondent number 4. All the respondents. For NF Railway, who will be appearing?
Railway, we have a separate study council.
Okay.
So only for one.
appears for respondent number 1. No formal notice need to be issued to respondent number 1. However, the petitioner is directed to furnish the copy of writ petition along with the annexures to the learned Central Government Council. As regards respondent number 2, 3, and 4, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with AD within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lord, may I have a prayer, my lord? Could it be fixed on Thursday, my lord, after 4 weeks? Any Thursday, my lord.
No, let the registry fix the date.
Very well, my lord.
When notice is not completed, so let the registry fix the date.
Yes.
Since notice is not completed, let the registry fix the date.
Let the
Very well, my lord. I'm so obliged, man.
From the supplementary cost list for motion, item number 27.
May I please, Your Lordship? Your Lordship, I am a retired employee of the Directorate of Treasuries and Accounts, Nagaland. Now, in the month of September 2020, I was issued officiating promotion from the post of SRDA, that is Senior Divisional Accountant, to the post of DAO, Divisional Accounts Officer, subject to the condition that I shall be required to pass the departmental examination as provided for under the Department Service Rules. Accordingly, I took charge in the month of November 2020, and I served in the rank and capacity of DAO till my retirement in February 2023. Now, my lord, Rule 9 and 10 of the Nagaland Treasuries and Accounts Service Rules 2001 provides that a person shall be accorded a maximum of 3 consecutive attempts to pass the departmental examination. Now, while I was in service, I was accorded only 2 opportunities, my lord. Thereafter, I retired in February 2023, and by the immune notification dated 5/7/23, the officiating promotion was rescinded and I was downgraded to the post of SRDA, my lord. Thereafter, in the month of July 2024, the department communicated to me to appear the departmental examination for the 3rd attempt, my lord, that is after my retirement. Now, as communicated to me by the department, I accordingly appeared the examination. The result was declared in the month of September 2024, and I passed the examination, my lord. However, the same was not considered by the state respondents, and the state respondents also failed to revoke the immune notification that rescinded my officiating promotion to the post of DAO. As such, my lord, I submitted a representation to the state respondents. However, the same was rejected.
We issue notice.
My lord.
Lord, Mr. What is your name? What is your name?
Why Hunzoy, my lord? Why Hunzoy?
Why Humse?
Hunzoy.
Humsoy. Heard Mr. Y. Humsoy, learned counsel for the petitioner. Also heard Miss A.I. me, learned additional learned government counsel appearing for state respondent. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner, namely Lima Thung Yang Than, impugning the letter number FIN/TA/ESTT/1-20/05 within bracket volume 4/160 dated 11/6 2025. So issue notice to the respondents. You are appearing for all the respondents.
Yes, Your Lordship, 1 to 5.
Since Miss A.I. me has appeared for respondent number, all the respondents, no formal notice need to be issued to the respondents. However, requisite numbers of the writ petition, copies of the writ petitions along with the annexures, shall be furnished to London Government Council by the petitioner within a period of
7 days, my lord.
within the course of the within a period of 7 days from the date of this order. List this matter after 4 weeks.
Obliged, my lord.
For motion, item number 28.
May I plead your lordship? Lordship, in the instant matter, I am aggrieved by the impugned order dated 06/08/2018 and order dated 14/11/2020, whereby the respondent number 5 and 7, the petitioner's late husband, service has been declared as deserter, and later on, after the gap of 3 years, his service has been dismissed. So I'm aggrieved with these two impugned order, your lordship. So here, lordship, in the instant matter, basically I am seeking family pension. So since my service has already been dismissed by the concerned authority, and during the course of
Which is the impugned order? You have
Uh,
not mentioned it in the cause title. In the cause title, you have mentioned.
Lordship?
In the cause title, have
Yes.
you mentioned about the impugned order? Okay. Okay. We are issuing notice.
Lordship.
Mr. What is your name?
P. Surin, lordship.
P. Suren, learned counsel for the petitioner. Also, Mr.
Jin Young Bom for your wording, madam.
Write his name. Learned counsel for the you are appearing for respondent number?
What for all the
All
respondents?
the learned counsel for all the respondents. This application under Article 226 of the Constitution of India has been filed by Ms. Mogaholi Zimo, impugning the order dated 8/6/2018 passed by the respondent number 5, whereby the husband of the petitioner was declared as a deserter. She has also impugned, full stop after full stop. She has also impugned the order dated 28/11/2020 passed by respondent number 7, whereby the husband of the petitioner was dismissed from service. Issue notice. Stop. Since Mr.
Jin Young Bom.
Be louder.
Jin Young Bom, madam.
Ching Yam Pom has appeared for the state respondents.
For the union, madam.
For all the respondents. No formal notice is required to be issued to the said respondent. However, the petitioner is directed to furnish requisite numbers of copies of writ petition along with the annexures to the learned counsel for the respondents within a period of today itself or
3 days, lordship.
within a period of 3 days from the date of this order. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Obliged.
For admission, item number 5.
May it please, my lord.
Yes.
Lordship, I have filed an additional affidavit yesterday, my lord, to
Yes.
place on record the information that I have received from an RTI application, my lord. The RTI application was 1,063 pages, but I have placed only 3 or 4 pages, the relevant information only.
Additional affidavit.
Yes, my lord.
When have you filed? Yesterday?
Yes, my lord. I have served copies to the respondents also, my lord. In fact, my lord, the annexures in the additional affidavit, I have annexed all those documents in my affidavit in reply to the affidavit in opposition filed by the respondents 1, 5, and 6, my lord. I actually wanted to seek the liberty of this honorable court. However, yesterday there was no single bench, which is why, my lord, in order not to delay the hearing of this case
What is
anymore.
the matter?
My lord, this regards to selection process
of
nurses, my lord.
Okay. Who are you?
My lord, we are
16, 17.
17 candidates, lordship, who were initially declared successful, but by the impugned corrigendum, our selection was rejected and the private respondents were included.
What was there in that said corrigendum?
Lordship, before I come to the corrigendum, I may be allowed to take my lord to the advertisement, the requisitions, I believe.
Yes.
If the facts.
Today, whether the matter can be heard finally.
Lordship, in case, if the affidavit, which we have been served copies of the additional affidavit, in case if the affidavit, your lordship is not in file, the lordship may call it must be the registry that might.
No,
be
it is,
called for.
the affidavit is there.
Okay, your lordship. Yes, your lordship. I won't, it's a short matter.
No, it need not to be short, but whether both parties are ready for final hearing. Okay, then let us proceed.
Lordship, here the petitioners, they have fought the good fight. They have run the good race, my lord. And we were declared successful, lordship. But the price, it has been connived to be given to the private respondents, lordship. Lordship will find the requisition slip at the last annexure
of the writ petition.
Affidavit in opposition filed by the private respondents, lordship, at page 176. This document was not with me when I filed my writ petition, which is why I did not enclose this. However, from the advertisement only I have enclosed. Page 176.
Legal first. Affidavit in reply.
Affidavit in opposition filed by the private respondents, my lord. It's a thick affidavit. I believe it is thicker than the writ petition.
Is it? Yes.
The last annexure, page 176, my lord. This is the requisition letter dated 28th of November 2022, my lord. Here, this letter is addressed by the Undersecretary to the Department of Health and Family Welfare, to the Secretary, Nagaland Staff Selection Board, lordship, where 62 posts of ANM/FHW. This were requisitioned to the NSSP for conducting selection process. Now, my lord, the educational qualification is at page 178, column 10. The last page, my lord, column 10. Educational and other qualifications prescribed for direct recruitment as per the relevant recruitment rules. 10 plus 2 undergraduate diploma in A&M. This is important, Lordship.
Yes.
Now, subsequent to this, Lordship, advertisement was issued by the NSSP.
This requisition was made by the Secretary.
Department of Health and Family Welfare.
Okay. Okay.
Yes.
For conducting the recruitment process.
Yes, my lord, my lord. NSSP, the respondents 2 and 3, they are the recruiting agency, Lordship.
Yes, where is the advertisement?
The advertisement, Lordship, it is at Annexure 1 of my writ petition. At page 26. Here, many vacancies were advertised. The post in question, Lordship, the A&M FHW is at item number 4 at page 26, my lord.
Yes.
A&M FHW.
61 posts.
Yes, my lord, 61 posts. Now, in that same advertisement, Lordship, at page 29, the first column, the educational qualification is provided.
Where?
Page 29, my lord. Page 29, the same annexure, the same advertisement, Lordship. Item 4. Here, the educational qualification is provided. A&M/FHW, Health and Family Welfare, 2 years course in A&M. So, consistent to the requisition letter, in the advertisement itself, the educational qualification was provided as 2 years course in A&M. Now, that very same annexure, my lord, this is important at page 33, so that I will not come back again to the same document, Lordship. At page 33, under the heading note, at column 11 and column 12. The board, that is the NSSP, the board will not entertain any relaxation in the educational qualification criteria from the department after the close of the registration.
Which para you are reading?
Page 33, note 11.
11.
11, yes, my lord, the top of the page.
Okay.
11 and 12 is important.
No relaxation
Yes,
as
Lordship.
regards educational.
Yes, Lordship.
Okay. Then
12, Lordship. The decision of the board in all matters regarding eligibility, conduct of examination, other tests, and selection would be final and binding on all candidates. Now, this is important. No representation or correspondence shall be entertained by the board in this regard. Now, Lordship, we, the petitioners, 17 of us, along with the other eligible candidates, Lordship, we participated. And our admit card and our certificate of course completion is at annexures 2A to, my lord, to QQ. That is from pages yes, 34 to 67, Lordship.
okay.
Now, my lord, after our participation in the selection process, Lordship, by notification dated 22 May 2024, the list of successful candidates, the roll numbers, Lordship, It was declared.
Results were declared.
Yes, Lordship.
Where is it?
Annexure 3, Lordship.
Page
68.
Yes. 69, 68.
Yes, Lordship. Now, to this part, Lordship, till notification dated 22/05/2024. Everything was going on in a legal manner, Lordship.
Yes.
Now, Lordship, after this notification was issued, the well choreographed drama of the respondents begins, Lordship. Because, Lordship, Annexure 4, on that very day, the respondent number 4, they submitted a representation, Lordship, despite the fact that in the advertisement at note 12, it is clearly stated that no representation shall be entertained from anyone. This representation was submitted and it was entertained, Lordship.
Which representation?
Page 72, Annexure 4. This is addressed to the Secretary of the Nagaland Staff Selection Board, Lordship. Written by the Secretary and the President of the Unemployed A&M Association of Nagaland.
Okay.
I may be allowed to read paragraphs 2 and 3, Lordship.
Yes.
The type copy, my lord, is at page 75 and 76 for my lord's convenience.
Yes.
2, I may be allowed to read paragraphs 2 and 3.
Yes.
That the basis of advertisement being unconditional and unspecified of any requirements or categorization, notwithstanding any pages, regardless of the year of passing A&M FHW course. Likewise, the eligible candidates who possess the required qualification as such, incorporating the A&M FHW, page of 2011, 12, 13, 14, consisting of Group A and Group B, also appeared in the exam on 24/02/2024. That awaiting a period of about 2 months, the result has been declared. Now, these are the private respondents, Lordship. They are saying that, Lordship, they have also participated in the selection process on the conditions prescribed in the advertisement. 3, thereafter notification number so-and-so, May 22, 2024, that is, was notified. Selecting eligible candidates for Waiwabosi for post under this representation was submitted by the association, that is the respondent number 4, to the respondents number 2 and 3. And Lordship, this is, I believe, one of the quickest representations ever to be considered, my lord, by the state. The very next day, Lordship, the impugned corrigendum, Annexure 5, Lordship. At page 77.
Yes.
It was issued, Lordship. By which, Lordship, 48 candidates who were selected by the notification dated 22/5/2024 were rejected and 68, Lordship, candidates were selected. Lordship, if replacement is to be done, Lordship, then 48 has to be replaced by 48. But the 48 candidates were replaced by another 68 candidates. Now,
the original list was of 68.
No, Lordship, the original is at it's about 170, Lordship.
Out of 170,
Yes, 170 something, Lordship.
48 were removed.
Yes, were removed and 68
New,
were added.
new roll numbers were
Yes,
included,
Lordship. Now, Lordship,
making it the list at around 190.
yes, Lordship, I think so. Lordship.
Okay.
Now, Lordship, the reason, the basis on which this impugned corrigendum was issued, Lordship, it is provided by the letter which was being issued by the respondents 2 and 3, Lordship, and addressed to the respondent number 4, which I have annexed at Annexure 6, page 78. The type copy, Lordship, is at page 79 to 80. My Lord, if I may be allowed to read paragraph 6, Lordship, instead of reading the entire document in order to save time.
What is this?
This, Lordship, is the letter.
Response to the
Yes.
association.
Yes.
In response to their memorandum.
Yes, in response to the representation.
Okay.
This letter was written, Lordship. And from here, one can make out on what basis, Lordship, the impugned corrigendum has been issued.
Yes. Yes.
6 at page 80 of the type copy, Lordship. Promptly, the results of ANM/FHW was re-examined and reviewed. The board has detected that the entire, Lordship, this is important, the entire list of FHW was omitted.
What is FHW?
Female health worker. Yes, Lordship. Entire list of FHW was omitted during the preparation of results of ANM FHW due to mentioning of only ANM in the requisite educational qualification at the time of registration. So, Lordship, the same stand has also been taken by the private respondents in paragraph 9 of their affidavit in opposition, my Lord. If I may be allowed to quickly take my Lord to paragraph 9 of the affidavit in opposition filed by the private respondents, so that we will not come back again, my Lord, to the same point. The words entire list is important, Lordship. 9, that the statements made in paragraph 8 and 9, if my Lord is
just
paragraph 9 is at page 8 of the affidavit in opposition filed by the private respondents.
Yes.
That the statements made in paragraph 8 and 9 of the petition are admitted to the extent borne by records. It is further stated that the contention of the petitioners is totally misconceived. The NSSB has issued the impugned corrigendum dated 23/5/2024 after having detected that the entire list of FHW was omitted during the preparation of results for ANM FHW due to mentioning of only ANM in the requisite educational qualification at the time of registration. Such rectification of omission on the part of NSSB by issuing the said impugned corrigendum does not amount to re-evaluation, so as to attract Rule 43 of the Nagaland Staff Selection Board. Lordship, this particular rule, I'll take my Lord to this rule later, Lordship. This categorically bars re-evaluation after the results are declared. So they are saying that since FHW was not mentioned as an educational qualification in the advertisement as well as in the requisition, the entire list of FHW applicants were left out. And none of the FHW were selected by the notification dated 22/5/2024. Now, my lord, out of the 68 candidates, new candidates selected by the impugned curriculum, I was able to impute only 67. Because I was unable to get the particulars of one candidate, Lordship, bearing roll number 3000810.
Yes.
However, his selection may also be deemed to be challenged, and the other 67 who are included may be treated as representatives, Lordship. Now, Lordship, the 48 cancelled candidates.
The 68th candidate.
Yes, Lordship.
His particulars were not available.
Yes, only his roll number I was able to obtain, Lordship. But now, after RTI, Lordship, I believe. No, I was unable to obtain till that, Lordship.
Okay. Yes.
Now, Lordship, thereafter, the 48 cancelled candidates, they also submitted representation to the NSSP, to the respondents 2 and 3. Thinking, Lordship, that as similar to the respondent number 4's representation, their representation shall also be treated promptly. On 30 May 2024, that representation was made. It is yet to be considered, to the best of our knowledge, till date. Thereafter, Lordship, write the notification dated 20 June 2024, which I have also impugned here, Lordship.
Where is that?
Annexure 8, page 83. Those candidates selected by the impugned corrigendum, Lordship, and those whose selection were not cancelled, and whose roll numbers appeared in notification dated 22/5/2024, they were invited for viva voce. For interview.
How the examination was, some written examination was held.
Yes, written examination was held. After that, Lordship, we were selected. After that, oral examination was to be conducted.
Okay.
Now, the list of successful candidates, Lordship, this is not the final selection list. Another round remains, Lordship. That is the interview round, Lordship.
Yes. No, by this notification dated 20 June 2024.
Yes, Lordship.
The successful candidates were called for viva voce.
Yes, Lordship. Lordship.
When date was fixed?
The date was fixed on 1st of July, Lordship, with effect from 1st of July 2024. Will commence from, so only the commencement that is provided, it would have.
So viva voce has not yet been held.
Yes, my lord, my lord.
Why?
Lordship,
is there any stay?
Yes, my lord. Stay
By
has been,
this
yes,
court?
at this stage of motion, stay was granted by this honorable court. So both the impugned corrigendum as well as this notification dated 26/2024 has been stayed by this
So
honorable
this is
court.
a matter of 2024.
Yes, Lordship. Lordship.
So those 68, 62 nurses are yet to be appointed.
Yes, Lordship, Lordship, Lordship.
Okay.
And because the records were not readily available with us, Lordship, we have filed 2 or 3 RTIs, Lordship, before the NSSP. Only after that, Lordship. Initially, our RTI was not, the information we requested was not furnished, Lordship, but later on they have obliged, Lordship.
Thereafter what?
Now, Lordship, the private respondents, 7 to 73, Lordship, they have participated with eyes wide open in the selection process. And when they were unsuccessful, they cannot make a U-turn and challenge the same selection process. That law is well settled, my lord. I may be allowed to refer to (1995) AIR SC 1088. Paragraph 9, Lordship. I may be allowed to read para 9, Lordship, at page 1093.
Yes.
Therefore, the result of the interview test on merits cannot be successfully challenged by a candidate who takes a chance to get selected at the said interview and who ultimately finds himself to be unsuccessful. It is also to be kept in view that in this petition we cannot sit as a court of appeal and try to reassess the relative merit of the concerned candidates who had been assessed at the oral interview, nor can the petitioners successfully urge before us that they were given less marks, though their performance was better. It is for the interview committee, which amongst others consisted of a sitting High Court judge, to judge the relative merits of the candidates who were orally interviewed in the light of the guidelines laid down by the relevant rules governing such interviews. Therefore, the assessment on merits as made by such an expert committee cannot be brought in challenge only on the ground that the assessment was not proper or justified, as that would be function of an appellate body, and we are certainly not acting as a court of appeal over the assessment made by such an expert committee. So the Lordship, on this same principle, Lordship, in order to satisfy my Lord that the law laid down is not disturbed till that, Lordship. 2023-17 SCC 147.
No, in the original advertisement.
Yes.
What was the educational?
A&M 2 years.
A&M 2 years.
Yes. Now they have added FHW.
Whether in the corrigendum in the advertisement has been issued. In the corrigendum was issued in respect of the results.
Yes, Lordship.
So how
no corrigendum was issued in respect of the advertisements, Lordship.
So how they became eligible?
By adding FHW, Lordship.
Where? Advertisement was not modified.
Yes, Lordship. Now they are stating that they have considered the FHW candidates as well, who have also participated in the selection. And
what is the difference between FHW and A&M?
Lordship, one is a female health worker, Lordship. They undergo, Lordship, different trainings, Lordship. Lordship, I'll come to that later, Lordship. That part, the rules and all this, Lordship. It is the nursing rules I have also placed before this honorable court in my affidavit.
But what is your main contention in this writ petition?
This is my main contention, Lordship.
That it was not provided in advertisement?
Yes, Lordship.
And
yes, Lordship.
During the course of recruitment?
Yes, Lordship. And that, Lordship, the respondents, as well as the NSSP, Lordship, they have not been honest, Lordship. I'll come to that, Lordship. They have manipulated facts. They have suppressed facts, Lordship.
No, just a minute. Let us go to the corrigendum once again.
Lordship.
That by which these...
Annexure 5, my lord, at page 77.
Your Lordship, permission, just for clarification, advertisement was contrary to the rules.
Oh, advertisement was...
In rule, ANM, FSW is there, and reduction was not as per the rule.
So in the corrigendum, whether that was mentioned?
No.
No, it's not mentioned, Lordship.
Okay.
I may be allowed to read the corrigendum, Lordship. It's a short corrigendum. Page 77. In pursuance to the ports CETSC 2023, result notification of event number dated 22 May 2024, the port has revised the written results of the undermentioned roll numbers with regard to combined educational and technical services examination 2023. Hence, candidates appearing the following roll numbers in ascending order have been declared qualified and eligible to appear for Viva Voce for CEDSC 2023. And the roll numbers are given. Selected candidates may download the detailed application form, DAF, along with annexure 5 so-and-so from the official website of the port and submit to the port's office with effect from so-and-so to so-and-so. Further candidates bearing the following roll numbers in ascending order who have previously been selected.
The reason mentioned in the corrigendum was that board has revised the.
Yes, Lordship.
So some revision was done.
Yes, Lordship.
And therefore new roll numbers were okay.
Yes.
Okay, yes. Proceed.
Now, Lordship, I may be allowed to place this ruling, Lordship.
Yes,
after that,
yes.
I'll.
What is the citation?
2023 17 SCC 147. Along the same lines as has been laid down in Matanlal in 1995. Para 39 is relevant, my lord. It appears at page 177. Para 39. It is therefore tried that candidates having taken part in the selection process without any demur or protest cannot challenge the same after having been declared unsuccessful. The candidates cannot appropriate and reappropriate at the same time. In other words, simply because the result of the selection process is not palatable to a candidate, he cannot allege that the process of interview was unfair or that there was some lacuna in the process. The representation that they have submitted on 22nd of May, it was submitted, Lordship, in agitation to the selection process, Lordship. Now, Lordship, the categorical stand taken by the respondents, Lordship, the state as well as the private, is that, Lordship, the entire list of FHW was omitted from selection, and no FHW was selected. However, Lordship, from the information that we have received from RTI, Lordship, that is not true. Because, Lordship, FHW candidates, 2 of them have been selected, Lordship.
In the original list?
Yes, in the original list.
Okay.
The additional affidavit that I have filed yesterday, Lordship, as well as the affidavit in reply that I have filed in to the affidavit in opposition filed by the respondents 1, 5, and 6, Lordship. I have annexed their admit card as well as their FHW certificates.
The additional affidavit, where is that statement? That 2 of the FSWs. Which para?
Lordship,
Para 3. Para 3 of your.
I'm having difficulty locating my affidavit, Lordship.
Additional affidavit which you filed yesterday.
Yes, Lordship.
Yes, I got it.
Yes, Lordship.
You have mentioned 2 roll numbers.
Yes, Lordship. Lordship, now, if my Lord will kindly go to pages 10 and 11, Lordship.
Of your
Additional affidavit, Lordship.
yes. Yes.
So, Lordship, this is the FHW certificate.
Oh.
This is markedly different, Lordship, from the A&M certificates that I have enclosed at Annexure 2 of my writ petition, Lordship, 2A to 2QQ.
The training course is of 1.5 years.
Lordship. The next page also, Lordship.
Okay.
We came to know about this, Lordship, only recently, Lordship. And we have our stand is clear, Lordship. We have no agitation against the notification, despite these two candidates being selected, Lordship. FHW candidates being selected. We have no agitation against the notification issued on 22nd of May, Lordship. That is the first result declared, Lordship. Now, Lordship, again, their admit cards also I have annexed, which I have obtained by RTL, Lordship. Annexure B and C, Lordship.
Okay.
Yes, Lordship. Now, the categorical stand taken by the respondents, the private respondents as well as the state respondents, is that the entire FHW list was omitted, Lordship. Now, Lordship, on the flip side, Lordship, the corrigendum, dated 23, the impugned corrigendum, Lordship, they are saying that, Lordship, in the impugned corrigendum, all the FHW candidates who were omitted and who should have been selected, they have been given the selection. Now, if that is so, Lordship, then, Lordship.
Now in the new list, whether these two are there.
Yes, Lordship, very much.
They are still there.
Their selection has not been disturbed, Lordship.
Okay.
It is only 48 out of 170 something, Lordship. 48 of us were rejected, were cancelled, Lordship, and 68 were selected in our place to face the Viva.
These results were declared on the basis of written examination.
Yes, Lordship. Yes.
Marks obtained by them.
Yes, my Lord. My Lord. My Lord.
Okay.
Now, Lordship, in the impugned corrigendum, Lordship, as well as by the letter written by the NSSP to the respondent number 4, as well as the private respondent's affidavit, they are saying that, Lordship, the entire list of FHW was omitted and the corrigendum was issued in order to accommodate those FHW candidates who otherwise would have been eligible to be selected, Lordship. If that is so, Lordship, this is important, Lordship. No A&M candidates should be there, Lordship, in the corrigendum, in the impugned corrigendum. However, Lordship, respondents
yes,
51 and 73, Lordship, they are A&M certificate holders. They are not FHW, Lordship. These actions show that it has been done, Lordship. The corrigendum was issued, Lordship, with intention to favor, illegally intention to favor the private respondents, Lordship. The A&M certificates, Lordship, of the private respondents 51 and 73 are annexed at the affidavit in opposition filed by the private respondents, Lordship, at page 67 and at page 96.
So their name were not there earlier.
No, their name were not there earlier. Indeed, notification dated 22/5/2024.
So whether 51 and 73 are A&M or FHW?
A&M.
Not FHW.
Not FHW, Lordship.
So those ANM who were not there in the original list,
Yes.
two were included in.
Yes, Lordship. If their stand is correct, Lordship, that only FHW were considered, then how come ANM are all two ANMs are included, Lordship?
Okay. Which is the recruiting agency?
Respondents 2 and 3, Lordship. The NSSP, Lordship.
Okay.
Now, my Lord, if I may be allowed to take my Lord to page 67.
Of the petition.
No, my Lord, the counter affidavit filed by the private respondents, the tick affidavit, Lordship, in page 67. Page 67 is the ANM certificate of the respondent, private respondent number 51.
Okay.
If my Lord will kindly quickly flip to the next page, Lordship, I have enclosed the FHW certificate of the private respondent number. I have enclosed private respondent number 52. My Lord can clearly make out the difference, Lordship, in the certificates. One is ANM certificate and the other is FHW certificate. Now again, Lordship, private respondent number 73. She is also a ANM certificate holder. 73, Lordship.
Okay, okay.
Her certificate is at page 96 of the affidavit in opposition filed by the private respondent.
Okay.
So, my Lord, the respondents, the private respondents as well as the state respondents, they have come with a ground that, Lordship, when in a dispute between the advertisement and the rules, Lordship, the rules will prevail. Lordship. But here, Lordship, it is not whether rules will have privacy.
Which is the applicable rules?
Lordship, the nursing rules, Lordship.
What is the name of that?
Nagaland Nursing Service Rules 1998, Lordship. I have annexed in my affidavit in reply to the affidavit in opposition filed by the respondents number 4, Lordship. Annex A.
Okay.
I may be allowed to take my Lord to the rules, Lordship.
In your affidavit in reply.
Yes, my Lord. To the affidavit in opposition filed by the respondents number 4. Respondent number 4, Lordship.
Page 11.
Page, yes. Page 11, my Lord. Page 11.
Yes. Yes.
Now the relevant portion is at page 24, Lordship. Here, Lordship. As rightly pointed out by the counsel for the private respondents at column 12, page 24, column 12. The qualification is given, Lordship.
Yes.
The name of the post is auxiliary nurse cum midwife / female health worker. 100%, Lordship, this is under the column direct recruitment. So, this is a direct recruitment post. No promotees, Lordship. An entry point, Lordship. Promotees, nil, Lordship. And the educational qualification, class 10 standard with 2 years training as ANM FHW. So, under the rules, Lordship, the FHW is also eligible, Lordship.
Okay. When the advertisement was issued?
Advertisement was issued on 15th of December 2023, Lordship.
And the applications were not scrutinized.
They were scrutinized, Lordship. But, Lordship, the FHW applications were also accepted, Lordship.
Okay.
Which is why, Lordship, in the representation written by the respondent number 4, that is the Association of the Unemployed ANM and FHWs, Lordship. In paragraph 2, which I have read earlier, Lordship, they have categorically stated that they have participated, all of them, all eligible candidates.
Okay.
Unless somebody voluntarily decided not to participate, all participated, Lordship, but they were not selected, Lordship. They are saying that pages from 2011, 2012, 13, and 14, none of the FHW were selected, Lordship. But that, Lordship, is not a condition in the advertisement. Otherwise, Lordship, if such a logic is adopted for employment in public services, Lordship, even for IAS, UPSC, and BSc exams, Lordship, somebody who graduated in 2005 may have a better opportunity, Lordship, to be selected over somebody who graduated in 2010. But be that as it may, Lordship, that is not a condition in the advertisement, Lordship. Now, Lordship, since FHW and this post, Lordship, ANM, they are 100% direct recruitment posts. How direct recruitment is to be conducted is also clearly provided under these same rules, Lordship. Rule 7, Lordship. Page 14 of the same affidavit, Lordship.
Yes. Yes.
Shall I read this, Lordship?
No, no, what is, you
It
tell me
says that,
this.
Lordship,
You made
for the selection, it has to be given, it will be given to a commission, Lordship. Examination shall be conducted and merit list will be declared. It does not speak about recruitment in batch-wise, Lordship.
So your main contention is that once result is declared.
Yes, Lordship. Lordship. Yes.
It cannot be revised.
Yes, and that the stand taken by the respondents that the rules shall have primacy over the advertisement. It shall not apply here, Lordship. Because FHW, Lordship, candidates were also selected, they also participated, Lordship. And just in order to illegally favor somebody, Lordship, the results, Lordship, the successful results of the respondents, of the petitioners, Lordship, they were cancelled in order to illegally accommodate the private respondents.
Okay.
And at the cost of repetition, Lordship, in the first notification, 2 FHW is there. In the impugned corrigendum, 2 ANM is there, Lordship. So it shows that, Lordship, all these actions were done arbitrarily with intention to favor the private respondents. And, Lordship, the private respondents as well as state respondents, they have not been honest before this honorable court. They have stated that the entire list of FHW has been omitted. Now, it amounts to suppression of material fact and misleading this honorable court, Lordship. Lordship, there are a plethora of judgments on this, but in order to save this court's time, Lordship, I would want to rely only upon one citation, Lordship. (2010) 14 SCC 38. Paragraph 21. It's a popular case. On this issue, my lord will find that these judgments have been quoted in catena of decisions, Lordship, para 21. The principle that the person who does not come to the court with clean hands is not entitled to be heard on the merits of his grievance, and in any case, such person is not entitled to any relief, is capable not only to the petitions filed under Articles 32, 226, and 136 of the Constitution, but also to the cases instituted in other courts and judicial forums. The object underlying the principle is that every court is not only entitled, but is duty bound to protect itself from unscrupulous litigants who do not have any respect for truth and who try to pollute the stream of justice by resorting to falsehood or by making misstatement or by suppressing facts which have a bearing on the adjudication of the issue arising in the case.
Yes.
Now, Lordship, Rule 43, which I have annexed to my petition, Lordship, the Nagaland Staff Selection Board rules, Lordship. Rule 43, the last annexure to my petition, Lordship. Annexure 9. Rule 43 appears at page 105, my lord.
No,
Rule 43, my petition, my lord.
petition.
Yes, my lord. Page 105.
Yes.
I may be allowed to read Rule 43, Lordship.
Yes.
After the declaration of the final result, re-evaluation of answer papers, scripts for examinations conducted under these regulations shall not be permitted under any circumstances. They are saying that review was done, Lordship. What cannot be done directly cannot also be done indirectly, Lordship. And if no re-evaluation was done, then how come, Lordship, the two A&M, that is private respondents 51 and 73 are present in the original? If only FXW, the omitted FXW candidates were selected, were included.
Okay.
Now, my lord, subject to the reply that I may be allowed to. Where's the additional? Yes. My lord, I have annexed the RTR covering letter, Lordship, for my lord's satisfaction, Lordship, in order that you have unnecessary confusion, my lord. At page 7 of the additional affidavit that I have filed, annexed A, Lordship.
Yes.
In order to satisfy this honorable court that this is indeed the genuine information that I have received, Lordship.
By this additional affidavit, what you want to show that?
Lordship, that
two.
Yes, FXW. They are saying that the entire list was omitted. If the entire list was omitted, how come the two FXW is present in the notification dated 22/5/2024, Lordship?
Why have you annexed the admit cards?
In order to show their roll number, Lordship, and their name, Lordship, so that my lord will be able to identify it with the A&M certificates, Lordship.
Because
in the A&M
in
certificate,
the
their
result
name is
sheet,
reflected.
in result sheet only
Roll number is
numbers.
present. Yes, Lordship. The roll number given in the admit card is present.
Okay, okay.
Hello. I'm
yes.
Your Lordship, I'm for state respondents 1, 5, and 6.
You are the recruiting agency.
No, Your Lordship. I'm the
Who is
state-
for the recruiting agency?
NSSB.
Moa Imchen. Okay. Let him submit first. Yes, Mr. Imchen. Why you issued the corrigendum?
May it bless your lordship. Lordship, I'll just take your lordship to my counter so that your lordship will be able to comprehend the counter file on behalf of respondent number 2 and 3.
Gilbert Hill. Affidavit in opposition filed by respondent number
2 and 3, your lordship. 2 and 3.
Got it. No, give me. You flag it in file. And right there, affidavit in. Yes.
Yes. Lordship, may I read from page 2, paragraph 3.
What is your contention?
I'll just read it out so that your lordship be able to comprehend. It's a very small issue, but petitioner is trying to make it complicated.
No, his only plea is that during the process of recruitment, after declaration of the results, you revise the.
Yes, lordship. The thing good with the qualification, lordship.
That is the.
Yes.
Okay, please read what you.
Yes, I'll just, lordship may appreciate page 2, paragraph 3.
Yes.
May I read?
Yes, please.
That the auxiliary nurses midwifery, hereinafter referred to as ANM, was previously called as female health workers, hereinafter referred to as FHW. The Indian Nursing Council formally established the NNM, the course in Pinsang, in the year 2016, and prior to the establishment of NNM, that course training were provided to FHW. It is pertinent to state hearing that those 2 courses syllabus are same, and only nomenclature was changed.
No, but from the certificates which have been produced for the female health worker, the course is
I'll come
of
to that.
1.5 years.
Your lordship, I'll come to that. I'll come to that.
This is my query. For ANM, the course is of 2 years.
I'll come to that.
Okay.
I'll come to that. that the petitioners are all NM holders and those who got selected in the updated merit list are all FHW, all batches except respondent number 51 and 73 who cleared NM course in the year 2018 and 2019 respectively. It is stated that the qualifications of the aforementioned respondents are evidently entered, recorded as female health worker FHW during the entry, due to which the results were not resolved in the initial result list, which considered only those candidates whose qualifications were recorded as auxiliary nurse midwife NNM. This error was subsequently rectified and the results were duly included in the revised result list. Your Worship, please appreciate that with regard to the educational qualification of the NNM FHW, the tribunal begs to state that the following for easy reference. Number A, Lordship appreciate that as per the Nagaland Nursing Service Rules 1988, the prescribed educational qualification is provided as class 10 with 2 years training in NNM FHWP. That by office letter number so and so, dated so and so, the Indian Nursing Council, its general meeting, the general body meeting held on 26 June 2021, 2011, I'm sorry, changed the eligibility criteria educational qualification for ANM as 12 pass instead of 10 pass. C, that by office letter number so and so, dated 16/12/2022, the principal director held in family welfare submitted a proposal to the government for appointment of 62 posts of auxiliary nurse midwifery NNM female health worker under Q system, Your Lordship. Prior to this enforcement of the Nagaland Staff Selection Board NSSP regulations 2020, the department has been effecting appointment under Q system. Subsequent to the implementation of the said regulations, the maintenance of the Q system has been entrusted to the Nagaland Staff Selection Board in accordance with the regulation 3.3c. As per the said provision, recruitment is to be carried out in the ratio of 50-50 from the existing Q and 50% through open competition. Wherein candidates enlisted in the queue are eligible to participate in the open competitive recruitment process. D, that upon examination, the NSSP, that means Nagaland Staff Selection Board, observed that the candidates eligible for appointment under the queue system included those possessing a minimum educational qualification of class 10, along with an FHW certificate as revised. Academic qualification criteria as implemented in the year 2011 and come into effect in 2012 as such, in good faith and based on verbal clarification, the NSSP in its advertisement dated 15/12/2023 annexure 1 to the repetition, the educational qualification was provided as 2 years course and NNM so as to accommodate both class 10 and class 12 pass candidates. This action and any manner constitute tampering or unauthorized alteration of qualification criteria, Your Lordship. Copy is there. Lordship, come to verify that with regard to the statement made in paragraph 2 of the read petition, the deponent begs to state that by office later, dated so and so, dated 16/11/2022, annexure 3, in the instant affidavit in opposition, the principal secretary, Health and Family Welfare, wrote to the government for proposal for appointment of 62 posts of ANN FHW under Q system, wherein it was given as follows. It is there, Your Lordship may appreciate. Thereafter, I'm coming to the next paragraph. by office letter showing so that is 16/11/2000, the principal director health and family welfare wrote to the government for proposal for requisition of 62 balls of ANM to the NSSB. Wherein the educational qualification as given as 10+2 diploma in NM. As such, the tribunal respectfully begs to state that out of the 124 balls, 62 balls of the NM FHW was to be appointed under the queue system and 62 balls was to be filled up by open competition requirement through NSSB. As such, the NSSB, in its advertisement dated 15/12/2023, Annex 1 of the writ petition, the educational qualification was provided as 2 years course in NNM, so as to accommodate both class 10 and 12 pass candidates. The answering tribunal further reached the 7 million so. Annexes, your lordship may appreciate. Paragraph 7, page 7, your lordship. That with regard to the statement made in paragraph 4, 5, 6, 7, and 8 of the writ petition, the tribunal begs to say that Nagaland Staff Selection Board, NSSB, acting in good faith and with intent to keep all the candidates informed, officially communicated through the auxiliary Nurses Midwifery Association president that the reason for cancellation of the petitioner's name was because the merit was revised after rightful inclusion of candidates with female health workers certificate, which were equivalent to diploma and NNM, and which was omitted in the result by notification dated 22/05/2024, Annex 3 of the writ petition, because the technical evaluator did not consider the FHW certificate strictly going by the educational qualification as per the advertisement, which is 2 years course and NNM. It was observed from the queue list documentation submitted by the department that FHW certificate holder goes through the same course as with holders of the NNM diploma, and both holders of the certificates have always been eligible for the boss of NNM. It is to be stated that the queue system held by the department, which has been appointing FHW certificate holder for the boss of NNM. While it is acknowledged that the reason was not specified in the coordinatum dated 23/5/2024, Annex 5 of the writ petition, the NSSB had anticipated that verbal communication with the NNM president would be sufficient. It was expected that the president NNM would effectively disseminate the information to NNM community members through various communication channels. However, in May 2024, the members of the NNM Association, including the President, General Secretary, and 2 members whose roll number got cancelled, met with the controller of examination. This meeting was convened at the request of the NNM Association President of Nagaland, and as the disqualified candidates refused to accept the results, despite the clear explanation provided by the NNM Association President and his members during the meeting, the controller of examination assured the active candidates that the cancellation was neither arbitrary nor unfair. That the qualified members, being unsatisfied with the verbal clarification provided by the controller of examinations and the assurance from the NNM Association President that the board has taken the appropriate corrective measures to record the requested written explanation. As such, the NSSB is so dated 29/05/2004, Annexes 6 to the writ petition keep detailed written clarification, which was then provided to the NNM Association President for dissemination among its members. The NSSB acknowledged receipt of the second representation clarification dated 30/05/2025, Annex 7 of the writ petition. However, The latter reiterated that the request for clarification and emphasized the need for improved communication. The board respectfully concluded that issuing the same explanation repeatedly would not be protective, and as such, no reply was given. As such, in view of the above explained facts and circumstances of the case, the deponent Baxter said that no discrimination, illegality, or unfair treatment was given or caused to the petitioners. Next para 8. Your Lordship, that with regard to the statement made in paragraph 9 of the writ petition, the deponent begs to state that, as explicitly stated in the Nagaland Staff Selection Regulation 2020, there is no provision for re-evaluation of answer papers or script at any stage of the examination process. It is known that the optical mark recognition OMR sheets include a carbon copy, allowing candidates to retain a copy of their answer sheet for self-assessment. This enables them to accurately calculate their scores, as the board only routinely provides answer keys after every examination. Furthermore, the terms review of results and re-evaluation of the answer scripts refer to two distinct processes. Re-evaluation involves assessing the candidates' OMR sheets, scanning them, and recalculating the final marks according to the answer keys. However, the review of the A&M results was undertaken by the board involved, verifying the total number of A&M candidates, validating the educational qualification certificates in the database, and rechecking of the rounds of disqualification for ineligible candidates. Thus, and the validity of the requested qualification, the final list of candidates for a viva voce was revised according to merit. It is emphasized that the candidates' scores were not altered. The merit list was adjusted based on eligibility and mark score, inclusive of both A&M and FHW. Both processes were subject to exclusive approval of the board. Hence, statements of the petitioners are apparently made mechanically without application of mind and assumptions to circumvent facts. Number 9, that the statement made in paragraph 10 of the writ petition is denied being false and misleading them and made without any application of mind. The deponent begs to state that the certificate of course completion of the NNM FHW are issued by the institution of Assam Nurses, Midwives, and Health Visitors Council, which the NNM School of Nursing District Hospital Tunsang falls under. As such, the statement that FHW is only a post name is totally baseless and misleading. It is an established fact that NM, FHW are used simultaneously, interchangeably, which the petitioners ought to have the knowledge since they all pass out at the seat institution, the NNM School of Nursing District Hospital Tunsang issues course completion certificate as course completed in NNM, and the governing body, that is the Assam Nurses, Midwives, and Health Visitors Council, has been issuing the completion certificate till 2021. Due to time constraint, the board verbally clarified the variant department regarding the validity of the FHW certificate for the post of NNM. Furthermore, till the date, the queue system for appointment to the post of NNM FHW consists of the candidates of both FHW certificates and NNM certificates. Then, Your Lordship, that with regard to the statement made in paragraph 10, 12, so and so of the writ petition, the answering department firmly refutes the assertion made by the petitioner.
What is this queue system? The earlier appointed will get earlier.
Queue system is first past first.
then why examination was held? If queue system is to be followed, why recruitment process has to be outsourced to a recruiting agencies? Then now what has previous year, then he will get appointment earlier. Now, why SS staff selection board is mentioning about queue system? Now 50 from direct recruitment. No, but the rules provide that 100% will be through direct recruitment. Okay. So 50% is through queue system. So while preparing the merit list, you considered that aspect also. Yes, Mr. Imchen, please continue.
I'll continue, Your Lordship. But then I was reading, Your Lordship, that with regard to the statement made in paragraph so and so of the writ petition, the answering deponent firmly refutes the assertion made by the petitioner that in no capacity the NSSP was also the sole authority to alter the syllabus or qualification criteria. It may only do so in consultation with the parent department. Parent department, that is Department of Health and Family Welfare, Your Lordship. It is recommended to state hearing that there was no clarification objection in the advertisement of the NSSP by the respondent number 5 and 6. That is the parent department, that is Department of Health and Family Welfare. In any manner, hence, the question of changing the rules of the game after the match is over is for facto baseless, unfounded, misconstrued, and manifestly supercilious. Furthermore, the deponent respectfully begs to state that the candidates with family health worker certificates who are initially excluded or never score if the syllabus and score content were different. However, FHW candidates, respondent number 7 to 73, scored higher marks than the 17 equipped petitioners. As such, the petitioners cannot presume that the FHW candidates did not complete the diploma and FHW. Last paragraph, Your Lordship. That with regard to the statement made in paragraph 16 of the writ petition, the answering deponent begs to say that the ratio 3.1 could not be maintained due to shortage of candidates in the reserve vacancies. Lordship, that is the stand of the NSSP. Respondent number 3 and 4. 2 and 3. That is the selection power.
Prima facie, it appears that NSSB has not done its job professionally as a recruitment body ought to have done. Yes. Miss Aimi, what is the stand of the government?
Your Lordship, the method of recruitment of ANM is governed by the Nagaland Nursing Service Rules 1960.
Yes.
And as per the rules, ANM falls under the cadre of Nagaland Nursing Subordinate Services, Class 3. Your Lordship, and Schedule 2, Clause 12, it says about the eligibility criteria. As earlier, it has been stated that the educational qualification is class 10, passed with 2 years training as A&M or FHW. Further, Your Lordship, for undergoing the course of A&M, FHW, the guidelines are laid down by the Indian Nursing Council. And as per their rules, they have changed the criteria for availing this training as 10+2 pass. So, Your Lordship, when the department submitted a requisition for 62 posts to the of A&M FHW, they mentioned in the format the education qualification is 10+2 diploma in A&M, Your Lordship. And this letter was this letter was given to the Secretary NSSB by letter dated 28/11/22, where they have clearly entered the education qualification as 10+2 diploma in A&M. So, Your Lordship, the department respondent 1, 5, and 6, they have no illegality has been committed by the department while submitting the said requisition form to the NSSB, Your Lordship.
Now, what is your response to the submissions made by Mr. Himchen that the after declaration of results, the results were revised after a representation came from the A&M Association, the Nurses Association.
Your Lordship, I have no comments on that, Your Lordship. That is purely there.
But your requisition was very categorical, stating therein that the educational qualification would be 10+2 A&M only.
Yes, Your Lordship. 10+2 with 2 years in A&M, Your Lordship.
Okay.
10+2 diploma in A&M.
Diploma in A&M.
Yes, Your Lordship.
Which is different from the.
No, Your Lordship, it's the same A&M and FHW. In the service rules also, it has been mentioned together.
No, it may be might have been mentioned together, but the courses are of different tenure. A&M is for 2 years. Diploma is the FHW is for 1.5 years.
But
So there must be some distinction.
But Your Lordship, they pertain to the same course.
Same course means whether a FHW certificate holder. What is the full form of A&M? Auxiliary midwife. Auxiliary nurse and midwife.
After completion of FHW training course, Your Lordship, the certificate which is issued to them is that of N. So they are equivalent, more or less similar, Mr. Lordship. In my opinion,
I'll come to.
Yes, I'll be.
Okay, let her complete.
Your Lordship, respondent 4 in their affidavit has enclosed annexure 4, where it is clarified to this query, to your query, Your Lordship. They might be allowed to.
Respondent.
Number 4, affidavit in opposition.
There are several affidavits in reply. One, 5, and 6. It is not there. Kind of. Yes, page.
Page 21, annexure 4.
Yes.
If I may be allowed to read, Your Lordship.
Yes.
This is to certify that auxiliary nurse midwife A&M / female health worker FHW is a 2 years course prescribed by the Indian Nursing Council. The nomenclature auxiliary nurse, midwife ANM slash female health worker FHW courses are equivalent and therefore registration certificate is issued by the Assam Nurse Midwives and Health Visitors Council slash Nagaland Nurse Council to ANM FHW on successful completion of 2 years course from institutions recognized by the Indian Nursing Councils to practice as registered midwife.
Yes, but it says that ANM slash FHW is a 2 years course. But
Yes, Your Lordship.
the certificates of the selected FHW, two candidates who were selected as FHW, shows that they have undergone course of 1.5 years only. Is there any course by name auxiliary nurse midwife slash female health worker?
Your Lordship, ANM is a course as well as a post.
Okay. No, where is that certificate which you are referring to, Mr. Sentianger?
In my additional affidavit, Lordship.
Additional affidavit?
Yes, which
you have filed today?
Yes, yesterday, Lordship. Annexures D and E, Lordship. Page 10 and 11.
Let me clarify. No, it is here. It is there.
And this by this.
You see those bunches.
We relied earlier also. That's affidavit.
Health others. 13th August. Yes. Annexure?
D and E, page 10 and 11, the last two pages.
And where is that ANM certificate? Any sample of ANM certificate?
Lordship, next year, A66 of the affidavit in opposition filed by the private respondents, page 96, Lordship. Page 96, the thickest affidavit, Lordship. Page 96.
What was the requisite qualification in the advertisement? Diploma in A&M. 10+2 A&M.
Yes, Lordship.
In the advertisement, it was just mentioned as 2 years course in A&M.
Yes.
And in the requisition format, it was mentioned as 10+2 diploma in A&M.
Diploma.
Diploma.
Now, the council is not the Assam Nurses, Midwife and Health Visitors Council, which is the issuing authority, is not issuing diplomas. Okay, okay. Your stand is that while giving requisition, you had specifically mentioned there regarding educational qualification 10+2
Diploma in A&M.
diploma in A&M. And as per the advertisement also same was mentioned there.
No, it's mentioned as 2 years course in A&M. 2 years course in A&M.
2 years course in A&M. Whether any clarification was sought? Recruitment agency is not a profession, has not acted in professional manner. No.
Lordship, in fact, 62 posts was requisitioned and 61 was advertised.
Okay.
It is for the first time that.
Okay. Yes, Mr. Zamir.
May I please, Lordship?
This is item number?
Item number 5.
Yes. Yes, Mr. Zamir.
Your Lordship, I'm looking for response number 7 to 73.
Those whose name were later on included.
Lordship. And before I take your Lordship to the pleadings, petitioner and the grounds for challenge, your Lordship, my first submission is that the petition is liable to be dismissed without considering on merit on the ground that there is deliberate and intentional misrepresentation of facts.
Misrepresentation of facts.
Of facts, natural facts, Your Lordship.
Okay, the petitioner has cited a ruling.
And Your Lordship, Your Lordship was surprised because though the interim order was passed, now after passing of the interim order and the matter relates to appointment of 61 posts of health worker, Your Lordship, and from Your Lordship expression, Your Lordship was be surprised, and now because of interim order, the selection process has been staged.
Yes, for so many years.
Yes. In fact, Your Lordship, I have filed an IA praying for vacation, Your Lordship, because at the time when the petition was filed, I have made a prayer that the details of the private respondents are not available. So as and when the details are available, they may be permitted to implead us as a party. So Your Lordship, after coming to know about the stay of the viva voce examination, Your Lordship, we have furnished the detail to the petitioner to implead us. Accordingly, after impleadment, recast petition was filed, Your Lordship, impleading us as respondent number 7 to 73, Your Lordship. Then thereafter, we have filed an IA for vacation of the interim order on the ground that there is misrepresentation of material facts. And the judgment which I relied on, in that IA, your lordship, that has been placed before your lordship today. Now, however, your lordship, the dishonorable court.
What facts were misrepresented?
Yes, I will be coming to that. And because since vacation will make the writ petition infructuous, and observation has been made that since public interest is involved, it should be disposed of as expeditiously as possible. That was the, but then the matter has dragged on because of non-filing of reply affidavit by the petitioner. And today, your lordship, we are taking up the matter. Now, on misrepresentation of facts, may I take your lordship to para 10 of the writ petition, page 17. I'll just read out one line.
Yes.
Para 10, writ petition, your worship. Page 17, 17.
Just a minute. There are many copies. This is the second copy. No? Keep it in a different place. Immediate.
That will be recast petition. Recast petition is the.
Which petition should we take? Recast.
Recast, your worship.
In recast petition, only cause title was changed. Or,
Yes.
Or some.
And then we were impeded.
Okay, I'm taking up the original writ petition.
Okay, page 17, pagination, because since many parties were implicated, maybe pagination may be different, but if that is para 10.
Okay.
Para 10, your worship. Because 60 of us were dated, so their pagination, there may be.
Page 17,
17, para 10, your worship.
Yes.
First line I will read out. That ANM is a course as well as a post, whereas FSW is only a post. This, I say, is a deliberate misrepresentation, your lordship, and this has been made knowingly to mislead this honorable court, your lordship. And why I say so? Because, your lordship, for undergoing the training course of ANM and FSW, your lordship, a common exam is conducted. For course, a common exam is conducted by the Directorate of Health and Family Welfare. So petitioners are very much aware that it is
now
a course.
How it is decided who will undergo.
Yes. Now that I leave it to the department. May I take your lordship to page 172?
But your from your submission itself, it implies that it is two different courses.
Yes. Page 172
of
affidavit in opposition.
Yes, 172.
Yes. Now, this is declaration of results for FSW/N examination 2024 to 2025. So a common exam is conducted for undergoing training course and for placement, your worship. Note 1. After the table bottom, admission, placement, and order for FSW NM will be issued on such and such. So, your lordship, petitioner has also appeared in the common exam and having participated in the common exam for undergoing ANM and FSW training course, the statement of the petitioner that FSW is not a course amounts to making a deliberate and intentional misstatement, your worship. And in my respectful submission, that has been made to mislead this honorable court, your worship. In fact, your worship, ANM and FSW courts, they are not only equivalent, but they are synonymous. And therefore, those who have undergone FSW training are also issued ANM certificate, your worship. May I take your
But
lordship?
how
Page-
will you justify
Page 12,
page 12 of?
that is based on record, your lordship. Whatever I am submitting, your lordship, that will be based on record. Page 12.
No, no, my query as regards the different tenures for both the courses.
It may be both the different courses, but they are equivalent. I will take your lordship to the record. Page 12, your lordship, of my affidavit of petition.
Yes.
So this is female health worker certificate, your lordship. This in respect of private response number 7. This is issued
Here
by-
also you have done 1 year, 6 months.
Yes, 1 year, 6 months. That period I will come, your worship. 1 year, 6 months. That period I will come, your worship. And next, may I take your worship to page 98. 98. Page 98, your worship.
Yes.
Page 12 is the completion of FHW course. And page 98 is the registration certificate, your worship. In respect of petitioner number, just I'm giving one example. And registered as ANM, auxiliary nurses midwifery, your worship. So even those who have got here, who have undergone FHW training, your lordship, registration certificate, they have been issued as ANM. So that is why I say they are equivalent synonymous, your lordship. In fact, this has been also certified by the Nagaland Nursing Council. The certificate, your lordship, is at page 173.
No, no. These two are different documents.
The same words.
No, I
A.
have some
Dole,
query.
your lordship. Srimati K.
No, yes, my query is
Lordship.
that the completion certificate of FHW course issued to Srimati Dolly
Yes.
was in the year 2014.
Yes.
So in the 2014, she completed FSW course for 6 months.
Yes.
And this is she's registered as ANM.
Yes. She has not undergone ANM training. She has undergone only FHW training. But on completion of the trade certificate of functional training, the registration certificate which is issued is as ANM. That is my submission, your lordship, and that is as per the record I am submitting. So what I want to impress your lordship is that they are equivalent. They are treated as equivalent, and this is also certified by the Nagaland Nursing Council. And certificate I have annexed, page 173. In support to substantiate this 173.
Yes.
Lordship has got it.
Yes.
This is a certified that ANM female health worker is a 2 years course prescribed by the Indian Nursing Council. The nomenclature ANM, FSW are equivalent, and therefore registration certificate is issued such and such, such and such.
Successful completion of 2 years course.
Yes, I'll be coming to that. I'll be coming to that, but for the time being, lordship, my submission is that ANM, FSW, they are equivalent. In fact, they are synonymous. And FSW is also a course. And in fact, for undergoing that course, a common exam is conducted both for A&M and FSW. And therefore, the statement made by the petitioner that FSW is not a course, when they themselves has participated in the common exam, Your Worship, that is a intentional and deliberate misrepresentation.
He has
Your
not
Worship.
stated it is not a course. He has stated it is only a post.
It's a post, but not, whereas if Your Lordship may write the sentence, A&M is a course and a post, FSW is only a post.
Yes.
That means it's not a post. It's not a course. Lordship may read this entire sentence.
Okay.
Lordship. So, and it has been held by the Honorable Apex Court that approaching the report, Your Lordship, one must come with clean hand, put forward all facts without concealing anything, Your Lordship. And if petitioner is guilty of misrepresentation or suppression of facts, Your Lordship, that petition must be dismissed without at the threshold, without considering the merit, Your Lordship. And in support, Your Lordship, I am relying on 2008, volume 12, SCC 481.
Yes.
Short paragraph, para 34, or para 34, 36, 38, and 39.
Yes.
Para 34. The jurisdiction of the Supreme Court under Article 32 and of the High Court under 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is, therefore, of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts of or the petitioner is guilty of misleading the court, I am on this, his petition may be dismissed at the threshold without considering the merit of the claim. Now, 36. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court will certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material facts or attempt to mislead the court may dismiss the action on that ground alone and may refuse to enter into merit of the case by stating, we will not listen to application because of what we have done. The rule has been evolved in the higher public interest to deter unscrupulous litigants from abusing the process of court by deceiving it. 38. The above principle have been accepted in our legal system also. As per settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of a high court under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or to pick and choose the facts he likes to disclose and to suppress or not to disclose other facts. The very basis of the writ jurisdiction rests in disclosure of true and complete facts. If material facts are suppressed or distorted, like in the present case, the very functioning of the writ court and exercise would become impossible. The petitioner must disclose all the facts having a bearing on the relief sought without any qualification. This is because the court knows law but not facts. If the primary object, as highlighted in Kensington such and such, is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hand. Suppression or concealment of material facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly, but state them in a distorted manner and mislead the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule and refuse to proceed further with the examination of the case on merits. If the court does not reject the petition on that ground, the court will be failing in its duty. In fact, such an applicant request to be dealt with contempt of court for abusing the process of court, Your Lordship. Now, my submission is this at the cost of repetition. In the common entrance examination for undergoing training course for NMW and FSW, petitioner have also taken part, Your Lordship, and saying that FSW is not a course but only a post that is, Your Lordship, a deliberate and intentional misrepresentation of material facts, Your Lordship, because here the matter relates to appointment to the post of ANM FSW, Your Lordship. So as per the law laid down by the IPAC Court, my respectful submission, the petition is liable to be dismissed without considering the merit, Your Lordship, on ground of misrepresentation, Your Lordship. Now, Your Lordship, to support that, I have another 2010 8 SSC 383, which has been relied upon. But I will read only para 34, 2010, volume 8 SSC 383. Para 34. Lordship has got it. Para 34. Yes. Lordship, may kindly, my pagination is at just relevant portion, page 396 in my decision. Next page, it will be 396.
Yes.
Second line, fraud is proved. Lordship has got it.
Yes, fraud is.
Fraud is proved when it is shown that a false representation has been made knowingly. So knowingly a false misrepresentation has been made, Your Lordship, that in fact that amounts to committing fraud on court, Your Lordship. Your Lordship, on merit, after the break, submit.
Yes. You have to address this court. Whether the board, staff selection board, maintain the sanctity of examination, recruitment process by issuing corrigendum without mentioning the reasons thereof for including certain roll numbers and deleting some roll numbers.
Okay, and that apart, Your Lordship, if it may cover, I will take only 3 grounds whether NSSP has tinkered with the educational qualification. That is one, because that is one ground taken. Second is whether Rule 43 has been violated, NSSP rule.
Say, Rule 43 prescribes that this post can be filled up by ANM /
No, evaluation.
Evaluation.
On evaluation.
No, that may not be. The petitioner has taken that stand.
Yes, and then
but otherwise also, if you, after declaration of the results, if you change the result.
Changing rule of the game. By changing rule of the game.
Yes.
So, going by the pleading, Your Lordship, the 3 grounds, mainly 3 grounds has been taken. On merit, I will deal with that, and whatever Your Lordship's query, Your Lordship, I'll do that. The ground for challenge as per the pleading, those are the 3 main grounds taken. That by accommodating me, that educational qualification has been tinkered by an SSP, and by re-evaluating, re-examining, Rule 43 of NSSP Regulation 2020 has been violated, and that the action of NSSP amounts to changing rule of the game after the match is over. So those 3 grounds, Your Lordship, and Your Lordship. Lordship. Okay.
Yes, I'm. Oh.
Yes, Miss.
His Lordship, I may be allowed to mention item 10 and two hearing matters. Item 10, I'm yet to find my reply to the filed by the respondents, Carmen. So I'll be filing it within two days. Then it can come up after 2 weeks.
Okay. Who is appearing for the government?
Item 10.
Who is appearing for the government?
I have taken consent.
We have taken
Yes.
consent.
And I-
Heard Mr. Foseko Forte, learned counsel for the petitioner who seeks how much time?
2 days. Within a week, I'll file my affidavit in reply.
Seeks a week's time for filing affidavit in reply. In this case, he submits that he has informed learned government counsel regarding his prayer for seeking time. Stop. The prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, I also like to mention item 23 and 24 from the hearing list. There are some, the respondents were also here, and I've taken the consent of the government also. I so if the matter can come up next Thursday on 21st.
What is the matter?
Lordship, it's regarding cancellation of the petitioner's appointment and accommodating the respondent on the ground that they have been appointed, they've been approved.
Did you have informed the private respondents council?
Yes, yes, they were here, but since they were in Dimapur, the road, due to the road condition.
You have informed them, no?
Yes, yes.
Okay.
Taken the consent of the government.
Heard Mr. Foseko Forte, learned counsel for the petitioner, who prays for an adjournment.
On 21st, we possible. It's a conscientious date.
An adjournment and submits that he has informed the learned government council for the respondent regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed on 21st August 2025.
Please, Lordship, Lordship, I'd like to mention item 22. On a joint prayer, Lordship, I pray this matter may be listed next week.
Let it be on Monday, Lordship. We can make an endeavor. Even if it is listed, it may not reach also like today. We have 2 or 3 cases listed, but then.
Whether a fixed date would be
If it's fixed date, then I prefer on Thursday.
Thursday.
Thursday will be risky, Lordship. Let it be on Monday.
Let us take that risk. Heard Mr. C.T. Zamir, learned senior counsel, appearing for the writ petitioner. Also heard Ms. V. Sokre, learned additional AG, on a joint prayer made by the learned counsel for both sides. Let this matter be listed on, what is the, on Thursday date is on 21st. 21st.
Much.
The interim
Yes,
order,
that may be
interim order shall continue till next. Yes, Mr. Zamir.
May I please, Lordship? Before the break, the Lordship wanted to know about query regarding the duration. The duration.
Yes, duration.
Or your Lordship, may I deal with the ground taken in the pleading and then I'll come to the duration, Lordship?
Yes, yes.
May I take your Lordship to the prayer? page 22, writ petition.
Yes.
Page 22, Your Lordship.
Yes.
Prayer number 1, Your Lordship, that is Sapara to petitioner Spring for quashing and setting aside the impugned corrigendum dated 23/5/2024. And HO5 to the writ petition, Your Lordship. And by this corrigendum, Your Lordship, the selection of the petitioner was cancelled and the private respondents were declared qualified for the viva voce, Your Lordship. And prayer number 2, 3, and 4, Sapara, Your Lordship. These are all consequential, Your Lordship. But impugned letter number such and such, which has been addressed to the association. Number 3, impugned notification number such and such to the should not be quashed and set aside to the extent it invites, that is the inviting the private respondent for viva voce. And a writ order direction should not be issued to the respondent, allowing the petitioner to face the viva voce as per the selection notified by notification dated 22/5/2024. So, Your Lordship, the prayer number, except the corrigendum, that is the main prayer, Your Lordship. Other 3 prayers are consequential. So, Your Lordship, my submission will be that the trust of my submission will be mainly on the corrigendum, Your Lordship. Now,
whether while exercising great jurisdiction, the court is bound by the prayers made by the
relief, Your Lordship, provided it is part of the pleading. Otherwise, the parties are bound by the pleading and whatever relief is being sought for, Your Lordship. But so far as writ jurisdiction is contrary to 26, Your Lordship, is a prerogative,
that is my query.
writ, Your Lordship. That I can say.
Suppose something has not been prayed for,
Lordship,
but court feels that under the circumstances it should be granted.
That prerogative, Your Lordship, yes.
It is there.
Yes, Your Lordship. Okay. That much, Your Lordship, under 226. So long if when the issue involves employment, public employment, Article 1416, Your Lordship, that. Now, 3 grounds taken, Your Lordship, mainly. May I take Your Lordship to page 16. Para 9, 10, and 13. Those are 3 grounds, main ground taken by the petitioner. Page 16, para 9.
Yes. One more query.
9, 10, and
one more query.
Lordship.
Suppose grounds are not specifically taken in the writ petition, but it
can be adduced from the pleading.
It came to the notice of the court while going through the records, about which nothing has been mentioned in the
pleadings.
Your
Lordship, that will be part of the relief, Your Lordship, because relief court can, if it involves a fundamental rights, part 3 violation of fundamental rights, Your Lordship, just because the relief has not been paid for, that cannot be, that cannot.
How it is different from the power exercised by a civil court?
That will be
bound by pleadings.
Pleadings under writ petition, under CPC are totally different, Your Lordship. That is one. Bharat Singh's case, Your Lordship. Whereas in the plaint, only the facts are to be stated, Your Lordship. But in writ petition, not only the facts, but supporting documents are also needs to be annexed, Your Lordship, in some, because evidence are not taken. Now, generally, Your Lordship, the parties are bound by the pleading. That is settled principle of law, Your Lordship. And parties are bound by the pleading. Why? Because the court has to go by the pleading. So far as relief is concerned, Your Lordship, though a relief is not prayed for, but if that can be deduced from
The materials available before the court.
yes, then relief yes. Because
While exercising writ jurisdiction.
while accessing the jurisdiction. That is my submission, Lordship, subject to your Lordship's satisfaction. Now coming to the ground, Your Lordship, Para 9, I will not take Your Lordship to the, I will not read out Your Lordship to save time. The content, one of the ground taken by the petitioner is that the corrigendum issued is in violation of Rule 43 of Nagaland Staff Selection Regulation 2020. That is one ground.
It prohibits re-evaluation.
Yes, Your Lordship. Rule 43 has been reproduced in the petition itself.
No, where is the corrigendum? At page?
Page 77, my lord. It's the impugn on after repetition.
Oh, it uses the word revised.
Revised. So, Your Lordship, here there is one ground taken. May I read out?
Yes.
It has been
Yes.
Rule 43 re-evaluation. After declaration of the final result, this is very relevant, Your Lordship. After declaration of the final result, re-evaluation, the word use of answer paper script for examination conducted under this regulation shall not be permitted under any circumstances. So one of the ground taken by the petitioner is that this corrigendum is in violation of Rule 43 of the regulation. That is one. Second is para 10, second ground. Para 11, sorry. So by para 11, by say another ground, second ground for challenge is that by issuing the corrigendum dated 25/3/2024, the NSSB has tinkered with the educational qualification.
Yes.
And the third ground, Your Worship, para 13, just relevant ground, page 18, Your Worship. Para 13, page 18, last few line. So, Lordship has got it?
Yes.
So the impugn corrigendum amounts to a changing rule of the game after the match is over. So these are the three grounds taken, Your Worship. Now, my submission, Your Worship, my first submission, Your Worship, will be on whether by issuing that corrigendum, impugn corrigendum dated 23/5/2024, the NSSB has tinkered with the educational qualification. My first submission on that. Now, in support, the petitioner has relied on the requisition letter. I will not take Your Lordship to that, sent by the Department of Health and Family Welfare, and also the advertisement issued by the NSSP, Nagaland Staff Selection Board. Also, condition number 11 to the advertisement issued by the board, which says that the board will not entertain any relaxation in educational qualification.
Oh, that stipulation is there.
Yes, stipulation is there. It's number 11 in the advertisement. Now, to that, my humble submission, Your Worship, is that the recruitment and condition of service of ANM and FSW, Your Worship, is governed by Nagaland Nursing Service Rule 1988. This is service rule, Your Worship. Lordship has got a service rule.
Where I can find it?
I'll
It is,
Lordship, I'll give extra.
no, it is annexed with some,
Yes.
which affidavit?
Reply to our.
Reply.
Lordship, I have extra copy for a road. I think it will be more convenient.
Yes.
Lordship may kindly come to schedule 2. Schedule 2 starts from page 11. About 4 page. Last.
Yes.
Schedule 2. Schedule 2, it mentions about the name of post and last column eligibility and other conditions. Now, relevant page will be page 13. Because we are concerned with A&M and FSW.
Yes.
And your lordship may also kindly take note that in cell number 12, auxiliary nurse come midwife / female health worker. Because
This is the name of the post.
this is the name of the post, A&M / FSW. In fact, even the schedule to the service rule.
What this slash means?
Slash, my respectful.
And or.
Or same. Your
Okay.
lordship.
Okay, I don't know. I am just asking you.
My suggestions. In fact, they are equated like.
Okay.
Now, educational qualification given the class 10 standard with 2 years training as A&M FSW. Now, this service rule of 1988, your lordship, still holding the field.
No, but it stipulates the tenure also.
Yes, I will be coming to that, your lordship. I'll be coming to that. That was your lordship query. After that, I will satisfy your lordship on that, your lordship. Now, this rule still holds the field. Now, may I take your lordship to page 176, my affidavit in opposition. Just my learned friend, he has also taken your lordship to this notification requisition letter. Last 3 page. Last 3 page from the book. Last 3 page. 176. This is the requisition letter.
Yes.
Sent by the Department of
Department.
Health and Family Welfare, your lordship. And page 178 is the last page. At serial number 10. Lordship has got it.
Yes.
Educational qualification for the post is 10+2 diploma in A&M. The lordship may say that as per the service rule, it is class 10.
Yes.
Rule does not say 10+2, your lordship.
Okay, but what was the advertisement?
Now, coming to the advertisement, at page 26 of the writ petition. Writ petition, your lordship, page 26.
Yes.
Now here, item number 4. This is the post we are concerned. You guys got it?
Yes.
A&M FSW. Now, educational qualification for A&M FSW is page 29. Item 4.
Yes.
Lordship has got it. 2 years course in A&M. It is neither class 10 pass nor 10+2, but 2 years course in A&M.
But there was no such requisition.
No,
While sending requisition,
10+2.
it is,
Service rule said class 10.
and the advertisement is silent.
It is silent. No class 10, no 10+2. So my respectful submission, Your Lordship, the requisition, the educational qualification mentioned both in the requisition letter by the Department of Health and Family Welfare and also the advertisement issued by NSSP, Your Lordship, is contrary to the educational qualification mentioned in the service rules of 1998, Your Lordship. And the law is well settled, Your Lordship, if qualification mentioned in the advertisement and inviting application are at variance, Your Lordship, with statutory provision will prevail, Your Lordship. And in that, Your Lordship, I may be allowed to take one case law, Your Lordship.
Yes.
I'm placing times to place case law. This is judgment passed by
Your respondent number?
Lordship?
7 to 73.
7 to 73. This is reported in 2023 SEC Online 1308 Union of India versus Uzair Imran. I am relying on para 11.
Yes.
7th line from top, para 11, Your Lordship. Law is well settled.
Yes.
Law is well settled that if qualification mentioned in an advertisement inviting applications are at variance with statutorily prescribed qualification, it is the latter that will prevail, Your Lordship. Therefore, Your Lordship, accordingly, it has been held by the Honorable Apex Court that advertisement which is contrary to the statutory rules, Your Lordship, must give way to the statutory prescription. And if one fulfills the qualification, the candidate cannot be denied appointment.
But the rules also.
And that is, Your Lordship, in the second case, Civil Appeal 152 of 2022, which copy of which I furnish, Your Lordship.
Yes.
The Employee State Insurance Corporation versus Union of India, Your Lordship. This is a judgment dated to para 20 and 21. This judgment dated January 20, 2022. Last page. Judgment date is their last page, Your Lordship.
Yes.
Para 2021. The advertisement issued by the applicant mentions that should be applicable in sessions. However, it is a settled principle of service jurisprudence that in the event of a conflict between a statement in advertisement and service regulation, the latter will prevail. That is just next, para 21, Your Lordship. I'll just read out relevant para. Para 21. Sub para 27 is here, Your Lordship. Any part of the advertisement, Lordship has got it?
Yes.
Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Thus, looking to the qualification prescribed in the statutory rules, the applicant fulfills the qualification and after being selected for the post, deny appointment to him as arbitrary and illegal. It is well settled that when there is a variance in the advertisement and in the statutory rules, it is the statutory rules which take precedence. As such, Your Lordship, in my respectful submission, Your Lordship, the impugned corrigendum dated 23/5/2024 issued by the NSSP, Your Lordship, is in consonance with the service rule. So as per the principle of law laid down by the Honorable Apex Court.
But service rule prescribes 10 standard with 2 years.
2 years. On 2 years duration, your lordship, I will come to that, your lordship, as I said, that
And
duration,
one more query,
lordship.
that the corrigendum does not state the reasons for
For
dealing-
issuing that corrigendum.
No, for including the names of this and
That,
deleting.
your lordship, that will be, I am not privy to that, that can be best answered by the. That cool. That cool. I don't know.
Okay.
So, your lordship, the impugned corrigendum issued is in consonance with the service rule. And as per the law laid down by the Honorable Apex Court, your lordship, there is no infirmity in the action of the NSSB in issuing the corrigendum, your lordship, which calls for the interference of this Honorable High Court. Therefore, the submission of the petitioner that the NSSB, by issuing the impugned corrigendum, has tinkered with the educational qualification is not legally sustainable, your lordship.
Okay.
Now, the second ground for challenge on Rule 43.
Yes.
Now, the NSSB Regulation 2020 has been annexed by the petitioner in the petition, your lordship, which is at page 105. The relevant portion. Page 105, 3 pages from last.
Yes.
Rule 40, your lordship has got it?
Yes.
After declaration of the final result, re-evaluation, as I've said, your lordship, this is, your lordship may kindly take note of it, the final result. Re-evaluation of answer paper script for examination conducted under this rule shall not be permitted under any circumstances, your lordship. Now, from a bare reading of the rule, your lordship, it is clear that firstly, Rule 43 will be attracted only after declaration of final result, your lordship. And final result, in my respectful submission, means the result which is declared after completion of the entire selection process. Lordship.
Yes.
And secondly, Rule 43 is strictly confined to re-evaluation of answer paper and answer script. Re-evaluation. Now, the corrigendum, impugned corrigendum 2023/5/2024, your lordship, relates to selection of candidate for viva voce, your lordship, which is only a part of the selection process, your lordship. In other words, the corrigendum is not a final result. Even the petitioner themselves has admitted that it is not a final result, your lordship.
Yes.
So the question of attracting or violating Rule 43 does not arise. Now, on the part of NSSB, your lordship, neither did they re-evaluate the answer paper or the answer script, your lordship. May I take your lordship to the affidavit of opposition filed by NSSB, your lordship, para 8. Para 8, your lordship, affidavit of opposition of response number 2 and 3. Affidavit of opposition, response number 2 and 3. Too many affidavit, reply affidavit.
How many affidavit, then reply affidavit? You give me the second one. Yes.
Yes. Relevant page will be page 19. Page 19, right? Oh, sorry, page 9, Your Worship, not 19.
Yes.
Para 8. I'll choose relevant para, I'll take sub-para. Furthermore, the term review of result, Your Lordship rightly noted the word review in the corrigendum, Your Lordship. The term review of result and re-evaluation of answer script refer to two distinct processes. Re-evaluation involves assessing the candidate OMR sheet, scanning them, and recalculating the final marks according to answers. However, the review of A&M result as undertaken by the board involved verifying the total number of A&M candidates, validating the educational qualification certificate entered in the database, so and so. So review and re-evaluation, Your Lordship, they have two different connotations. So Rule 43 of the Regulation 2020 bars only re-evaluation of answer script and answer paper. It does not bar the NSSP to review, Your Lordship. And moreover, Your Lordship, Rule 43 will be activated only when final result is declared. Therefore, the grounds taken by the petitioner in challenging the impugned corrigendum dated 23/5/2024, Your Lordship, is totally misconceived and not legally sustainable. Last ground, Your Lordship, the third ground, that NSSB, the action of the NSSB amounts to changing rule of the game after the match is over, which is not permissible. That is the ground taken. Now, as under submitted, Your Lordship, the educational qualification as mentioned in the requisition letter and also the advertisement is contrary to the educational qualification prescribed in the Service Rule of 1988. Now, as stated, the law is very clear that recruitment to Service Rule can only be made in accordance with rule, and error, if any, in the advertisement, Your Lordship, cannot override the rules and create a right in favor of a candidate, Your Lordship. So the impugned corrigendum dated 23/5/2024, Your Lordship, is in consonance and in conformity with the Service Rule of 1988, Your Lordship, and also as per the law laid down by the Honorable Apex Court, which I have already placed before Your Lordship, Your Lordship. Now, the action of the NSSB in issuing the corrigendum does not amount to changing rule of the game after the match is over, Your Lordship. Now, so even the third ground taken by the petitioner is totally misconceived and not legally sustainable, Your Lordship. And in my respectful submission, there is no merit in the writ petition, and in fact, the petition is liable to be dismissed, Your Lordship. Now, in reply to, apart from the grounds taken, Your Lordship, in the pleading, the learned counsel for the petitioner has also taken additional ground in the submission. And first is that having participated in the selection process, I cannot challenge the selection process. And in support, he has relied on 1995 AR Supreme Court 1088 and also 2022 17 SEC 147, Your Lordship. Now, 23, Your Lordship. No, Your Lordship, I have not challenged the selection process, Your Lordship. In fact, by challenging the corrigendum, he is challenging the selection process. It should be, it's otherwise, Your Lordship. I think I should be placing Your Lordship those decisions. So that ground is, Your Lordship, is not, that submission is not legally sustainable, Your Lordship. And it has also been submitted that this is one of the fastest disposal of representation, Your Lordship. Just because the representation has been disposed of by the NSSP immediately, that cannot be a ground to interfere unless a malafide is alleged, Your Lordship. And this is not a case where malafide has been alleged by the petitioner.
Which law regulates the staff selection board, how they should conduct examinations, what should be the timeline, what should be is there any regulation?
I've gone only through the relevant portion of the NSSP Regulation 2020, Your Lordship. That specific provision, I'll have to check otherwise regulation is annexed in the writ petition, starting from page 87.
Page?
87. And that is a very pertinent question. Page 87, writ petition.
Yes, okay.
My apology, Your Lordship, but I have concentrated only on Rule 43, on which ground the curriculum has been challenged by the petitioner. Lordship has got it?
Yes, yes.
Page 87, this Nagaland Staff Selection Board Regulation, Your Lordship, composition of the board. But here, Your Lordship, the NSSP, the Council for the NSSP has taken Your Lordship to Rule 3C. Rule 3, Sub-Rule 3C. Lordship.
No, it lays down
that ratio, whatever.
In part 2,
Yes.
conduct of examination, when requisition should be sent, how it should be sent, then
regarding how requisition has to be sent, I think that will be for the parent department, health and family welfare.
no, when application forms are to be scrutinized, it lays down a procedure to be followed by staff selection board. From Rule 14 onwards,
sending requisition and issue advertisement.
what could be the condition of the eligibility?
Document. Scrutiny of application form condition. Yes, it starts from conduct of examination, it starts from 14. Lordship is right.
Okay. Okay. Both the parties have raised only Rule 40.
Lordship.
The petitioner is also relying on Rule 43. Okay.
But my contention is that Rule 43
is
will
not
get-
applicable.
Yes. Now, coming to the duration, Your Lordship, that will the Lordship query, Your Lordship.
Yes. The stipulation regarding duration is there in the rules also,
Yes, 2 years.
as well as in the advertisement also.
Yes. Now, Your Lordship, so far as duration of the course is concerned, A&M, FSW, Your Lordship, the duration is done by the Indian Nursing Council. Your Lordship may kindly see the affidavit of opposition filed by respondent number, the state respondent 1, 5, and 6. One, 5, and 6, the respondent. The Learner Council for the State Respondent has taken your lordship to that annexure also.
It is very difficult to find.
1, 5, and 6. 1, 5.
When
Lordship has got it. Page 14, last page.
Yes.
This is part of the annexure, annexed by the state respondent. And this is issued by Indian Nursing Council, which is a statutory body under the Ministry of Health and Family Welfare. Number 4, serial number 4. The minimum educational requirement shall be the passing of class 12 years of schooling, 10 plus 2 years course recognized by such and such, or a recognized equivalent examination, Your Lordship. Now, Your Lordship, regarding the duration of the course for A&M FSW, Your Lordship, now it is fixed by the Indian Nursing Council, Lordship. The eligibility criteria for undergoing the training, what will be the duration of the course, that is fixed, determined by the Indian Nursing Council, Lordship. Now, initially, that is since 1940s, Lordship, that is my information, that the duration was 2 years initially. And from 1970s, I am informed it is 77, Your Lordship, the duration was made 1 year, 6 months, Your Lordship.
For A&M.
Initially it was 2 years, the duration was 2 years. Then in 1970s, the duration was brought down, reduced to 1 year, 6 months. And Your Lordship, now here the date is not, the year is not mentioned, but I am informed that from 2012, the duration, they have increased the duration to again to 2 years. My information, Your Lordship.
From
2012. Though here, that is, the year is not mentioned in the notification, but my information, Your Lordship, the subject to verification. Now, as I've stated, Your Lordship, though the duration was changed by the Indian Nursing Council from time to time, the 1988 rule, service rule, still holds the field. Rule has not been amended, Your Lordship. And since its inception, the institute at Tunsang, the training, the duration of the training course for FHW, that is the state government, Your Lordship, is 1 year, 6 months, Your Lordship. That is the institute, state government institute, Your Lordship, where all training is given, training course is given. The duration is 1 year, 6 months, Your Lordship. And it is because of the reason that though the training, the FHW training course is only for 1 year, 6 months, the certificate, I've taken Your Lordship to the certificate issued on completion of the training, Your Lordship, is that of A&M, Your Lordship. So both FHW and A&M, they were treated as equal, the course whoever taken, Your Lordship. And that is the problem with the duration. The duration it changed from time to time.
But how you address that?
Yes, Your Lordship.
What is
Then
it?
I'll have to leave it to Your Lordship. But that is a fact. That is a fact. Though the rule says that, since in fact the state government was also imparting the training for 1 year, 6 months, Your Lordship. Though the rule says it is 2 years course. There is no institute, Your Lordship, imparting 2 years course. So, of course, different point of time, Your Lordship. The rule remains the same, 2 years, but then it changed from time to time, the duration. So in my respectful submission, Your Lordship, the duration, in my subject to your lordship's satisfaction, need not be so strictly interpreted so as to debar all those candidates like the private respondents who have only undertaken 1 year, 6 months course, your lordship. We by the state government. If your lordship strictly interpret that, your lordship, now what will happen to all of us who have undertaken, who have undergone only 1 year, 6 months training course, your lordship?
Because the post advertised was of A&M as well as FSW.
And it is the state government institute which has been imparting, giving us the training for 1 year, 6 months. And every year, so many of us have completed training. Since 2011, your lordship, the petitions are here, we have completed training in the year 2011, your lordship. Now, if your lordship, in the interest of justice, equity, your lordship. Now, if the lordship interprets strictly, no, it has to be 2 years, then where would we go? And in my respectful submission, your lordship, this is a case where a human approach needs to be taken, your lordship. And it is not the case of the parent department, the Department of Health and Family Welfare, nor is the case of NSSP that we don't possess 2 years training course. It is only the petitioner who has raised the issue. And this has been practiced. This is not for the first time, your lordship. After NSSP, this is for the first time that they have conducted the recruitment process, your lordship. Even those who have, my predecessor, your lordship, who have passed out from the same institute with 1 year, 6 months training course and with certificate of A&M, your lordship. They are already employed.
But at that time, this staff selection board was not there.
Not there. It has come now. It has come now, your lordship. But the rule was there. 1988 rule was there, your lordship. So all along, your lordship, though that rule was there, we have been equated with FSW A&M same put the degree, your lordship.
Okay.
So that is my humble submission, your lordship. Much obliged.
You are for?
Lordship, I am for respondent number 4.
Who is respondent number 4?
The association.
The association.
Yes, Lordship. My name is not, in fact, reflected in the post list.
I forgot your name.
Lordship.
I forgot your name.
Apok Ponganan, A. Ponganan. In short.
Okay. For R4.
Yes, Lord.
What is your submission?
Lordship, my humble submission before I go into the
You represent both the petitioner as well as
Lordship, I am sandwiched.
respondent.
I am sandwiched. In fact, my learned friend in the petitioner side has been pointing finger at me that I made a representation, and because of that, these cases become complicated. But Lordship, all of us are members of the same association. This association is an unregistered association, Lordship.
Yes.
We have no constitution, but we got together and decided to form an association to seek justice for those grievances that we have been facing, the unemployed nurses. So, Lordship, both the petitioner as well as the private respondents and many others are members of.
What is the difference between this A&M as well as FSH?
Lordship, only the name. The border sake, Lordship. The only grievance before when we submitted the representation on 22nd, when the results for the written examination was declared, that we found out that none of the candidates belonging to the earlier batch of 2011, 12, 13, and 14. That is exactly
That
what
was that was your main grievance.
that was
That
our
ol-
everybody went together. We all went.
that older batch
Yes.
have
were-
been
yes.
excluded.
Lordship, the two two certificate that my learned friend has added in the additional affidavit belong to the 2016 batch. Lordship will kindly see the additional affidavit.
If it is 2016 batch,
Yes.
what it implies? What it implies? Why are you making that submission?
Lordship, the petitioner have shown a certificate that those certificate to show that the female health workers were selected. The only grievance, as I've stated, that we had was that the earlier batches belonging to the 2011 to 14, none of them were considered. That was the grievance we have. That is what we have stated in our representation.
Okay.
So what they are trying to show.
What was told to you by the
Lordship, a part of.
No, after you submitted a representation, the
Everything was
corrigendum
explained to us, and by the later dated.
Listen to my query.
Yes.
You submitted a representation.
Yes, sir.
Immediately on the next day, a corrigendum was published.
Yes.
Thereafter, the staff selection board wrote a letter to you.
On 29th.
What was mentioned therein?
Lordship, I'll take your lordship to that. But before I go to that, lordship, on that day we made along with the representation. Members who were selected earlier by the first select list were part of the delegation. All of us went together, and the staff selection board, Nagaland State Selection Board, the elaborately explained the procedure. Verbally, no written papers were given to us.
What was explained?
Lordship, that has been explained in the letter, which is annexed, Lordship, on 29/5/2025. Lordship, may kindly go to the annexure 6 of the petition.
The petition.
Yes.
Page number?
That will be 78. But the type copy with a better is 77, Lordship. That my
That we have-
my friend has taken your Lordship.
We have gone through.
So this, the contents of this letter was explained to us on 22nd. Nine, rather, no? Yes. Page 79.
Okay.
Oh.
During data entry, they found that
Yes.
those who were with
Not
SHW
assessed.
were excluded.
Yes. Lordship, the association represents the welfare of all the nurses. I have nothing against anybody, but because some of our older members were not, Lordship, I myself, I was the president at the relevant point of time. I failed, Lordship. My secretary also failed. We were not in the select list. But we are still pursuing the matter for the benefit of all the members of the association. Worship, in our representation.
Now, what is your stand in this case?
Lordship, as I've said, I am for the welfare of all the nurses, but my submission is that the selection process should have been transparent. Then our case to belonging to the earlier batches of from 2011 to 2014.
Yes.
To include those persons who have passed out earlier. So that is why we made it. We discuss it among ourselves, and then we made the representation. So that everybody will get a fair chance.
Okay. But you were not knowing that at that time that there was some
what?
The names of SHW were
No, in terms of the result declared, we came to know, Lord. That's why only we win.
okay.
Otherwise, there was no point. Lordship, both my learned friends who have submitted earlier has taken your lordship to the advertisement, requisition as well as the advertisement. I don't want to go there. But both the requisition as well as the advertisement is not in conformity with the statutory rules of 1988. So all three have mentioned different.
Yes.
And lordship, that point I have taken in my affidavit in opposition.
Which para?
Lordship, the petition, how may I take your lordship to the petition first? Para 10 of the petition. Which my learned friend has also referred.
Yes.
Lordship, the petitioner is
That it
alleging
is a
that.
post.
Yes,
It is not a course.
that's right, lordship. And I have taken that in the para 10 of my affidavit in opposition, saying that both are training course as well as a post. Now, in answer to that, lordship, in the affidavit in reply filed by the petitioners, if your lordship, may I take your lordship to the affidavit in reply?
Dated?
Lordship, it is 12/8/2025.
Yes.
This is in reply to the affidavit in opposition of the respondent number 4.
Yes.
Lordship, para 10.
Yes.
In reply to my statement that both are course as well as a pause, they have replied in this manner, Lord.
So they are not denying.
Yes.
They are admitting.
They have admitted it.
Okay.
No justification has been shown. And the lordship, in my affidavit, I have annexed one document that my learned government advocate has shown, that page 21.
What is it?
This is certificate issued by the Nagaland Nursing Council
Yes.
Your Lordship has already said it, that
Yes.
stating that NNM as well as female health workers are equivalent. That is annexure 4 to my affidavit, Lordship. Lordship, may I read it?
No, we have gone through it twice.
So the issue that these two are different does not arise in this present case. And Lordship has already sent the rule, so I don't need to revisit that. Lordship, lastly, the ground taken by the petitioner that the NSSP has violated the Rule 43 of the regulation, Regulation 43, that is misconceived, Lordship, because the word used is re-evaluation. In the present case, it was revised because of the discrepancies that was detected in the system.
Yes.
So, Lordship, I humbly submit to your Lordship that the petition does not merit the consideration of this honorable court.
You have anything to say?
Yes, my lord.
Very brief.
Yes, my lord. I'll be very brief, Lordship. One, the counsel for the NSSP, the respondents 2 and 3.
Yes.
Besides the common grounds that all the respondents have taken, he has taken one unique ground. I'll only reply to that. Then, in paragraph 7, Lordship, of his affidavit in opposition,
Yes.
that there is a queue system, Lordship. That is the stand.
Yes.
Amongst the ANM FHW, and then that ought to have been followed. Now, my lord.
In which para?
Paragraph 7, Lordship. He has stated two things there. Firstly, that because of the non-inclusion of the FHW, the technical evaluator, he has totally not considered the FHWs. Secondly, Lordship.
Yes.
Regarding the queue system, Lordship. Now, my lord.
What has been stated with regard to queue system?
I may be allowed to read. It was observed from the queue list recommendation submitted by the department that FHW certificate alters to the.
No, who informed the SSB about the queue system? The SSB got requisition from the department.
Yes, my lord.
According to that, it advertised.
Yes, my lord.
Then where was the occasion to?
Yes, my lord. There is nothing.
No, what is the statement?
Yes. Regarding that, in the requisition letters, Lordship.
It has been.
It is silent, Lordship, regarding the queue system, Lordship. And in the advertisement also, there is not even a whisper, Lordship. Now, Lordship, the law laid down in 2011-12 SSC 85 by the Honorable Supreme Court, Lordship, is that if there is any relaxation, even if it is provided under the rules, Lordship, it should be mentioned in the advertisement.
2011?
12 SSC 85. Petanga Taluktar versus Saifullah Khan. In para 29, my lord.
That it has to be, the relaxation has to be mentioned in the
Yes, my lord.
advertisement.
Yes.
Okay.
Shall I read this or?
No, I'll go through it.
My lord. Lordship, this honorable court also, in a decision reported in 2014, 6 GLR, Lordship, not GLD, GLR, 439 in paragraph 28. Dinimena versus Terra Arunachal Pradesh.
2014?
6 GLR 439.
What it says? Para?
Para 28. The same principle, Lordship. That if there is any relaxation, even it must be which is provided under the rules. If it is not provided in the advertisement, it cannot be provided. So, at the cost of repetition, the queue system is not even being whispered in the advertisement, nor in the requisition letters. Secondly, Lordship, as my Lord has rightly pointed out, no reasons has been ascribed in the impugned original at page 77, Annexure 5 to my writ petition.
Okay.
I may be allowed to read one sentence, Lordship.
Yes.
AIR 1978, Supreme Court 851. Paragraph 8, Lordship.
Yes.
The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order paid in the beginning may, by the time it comes to the court on account of a challenge, get validated by the additional grounds later brought up. We may hear. Lordship.
Yes.
So no reasons, Lordship. There. Therefore, it deserves to be indiffered with, my lord, the impugned original. Now, Lordship, coming to the submissions made by the learned counsel for the private respondents, 7 to 73. Lordship, he has mentioned that I have been deliberately delaying the hearing of this instant petition. Lordship, I never indulged in. Lordship, in fact, the private respondents filed their affidavit only on 18th of March, and the respondent number 4 filed his affidavit on 18th of June, Lordship, this year. And after I filed my, it's only 14th of August, I filed my affidavit, it has been fixed for admission hearing, my lord. So at no point of time did I indulge in, Lordship, deliberately delaying the hearing of the instant petition, Lordship. Now, Lordship, the stand taken by the respondents that Rule 43 of the INSSP is not attractive, Lordship. Now, Lordship, review, reassessment, whatever name they may have called, Lordship, even if you call an elephant a mouse, it will not change the character of the elephant, Lordship. Now,
no, but they are saying it was not elephant, it was mouse.
Yes, Lordship. Which is why, Lordship,
they review.
Yes, review, revision, reassessment, all these are not provided under the rules, Lordship. It is not defined.
The submission is that
there is no scope.
Re-evaluation of answer script is prohibited under 43.
Lordship, yes, re-evaluation, and Lordship, it does not, the rules does not provide for review.
Okay, that may be a submission.
Yes, Lordship.
And what is your submission regarding suppression of fact by you?
Lordship, I did not suppress, Lordship.
You said in your writ petition that SHW is only a post. Use of the word only.
Lordship. Now, Lordship, in the course, this sometimes, Lordship, people make bona fide mistakes, Lordship. Not with intention to mislead this honorable court, Lordship. The ear is human, Lordship.
Okay.
And I beg the indulgence of this honorable court, Lordship, that, and Lordship, which is why that stand has not been maintained in my affidavit in reply, Lordship. Now, Lordship, the private respondents, the counsel for the private respondents, they have tried to make it appear as if this is a battle between the rules and the advertisement, Lordship. It is not so, Lordship. Why? Because the decision laid down in Matanlal and in 2023, Lordship, that somebody who has taken a calculated chance, Lordship, if, Lordship, the private respondents, if they had decided not to participate, and if they have challenged, Lordship, they have participated, Lordship, NSSP did not bar them, they even got selected, Lordship, 2 of them, Lordship, which they have suppressed from this honorable court.
No, is it your submission that they have not challenged the advertisement?
Yes, Lordship. They have not challenged the advertisement, Lordship.
Where SH W was not included.
Yes, Lordship. Yes, female health worker was not included, Lordship. But despite that, Lordship, they were allowed to participate by the NSSP, Lordship, by the respondents 2 and 3. And they have been selected, Lordship.
Okay.
And having taken a calculated chance, Lordship, the unsuccessful candidates, they cannot take a U-turn, Lordship. They cannot have the best of both worlds, Lordship.
Okay. Heard Mr. Senti Anger, London, counsel for the petitioner. Also heard Miss A. Aimi, London Government Council appearing for respond 1, 5, and 6.
Lordship, I would like to make a single sentence reply to the respondent number 4.
Let me dictate that part. Then you.
My lord, my lord.
Also heard Mr. Muaz Zamir, London Senior Government Council appearing for respondent number 3 and 4. 2 and 3. Also heard Mr. A. Ponganer appearing for respondent number 4, as well as Mr. T.B. Jamir appearing for respondent number 7 to 76. 7 to 73. The hearing concluded, judgment reserved. Yes, what you wanted to say?
In the advertisement, Lordship, page-wise selection is not a criteria, Lordship. And Lordship, they themselves have admitted, Lordship, that FHW was selected, Lordship. In the notification dated 22/5/2024, Lordship, not the impugned curriculum, Lordship. Whereas they have stated that, Lordship, the entire list of FHW was omitted, Lordship, which is false. Their action speaks louder than words, Lordship.
We're only saying, Lordship, up to 2014.
That page-wise is not a criteria in the advertisement.
Now you have to wait for judgment.
Otherwise, we hear the matter again. Obliged, Lordship.
I am deeply obliged, Lordship.
For unlisted motion, item number 29.
Albert, arrange it in a proper way. Files. I have mixed everything. Before giving it to me, systematically arrange. Keep the judgments, the printout of the judgments in a separate file. Okay. Yes, Mr.
Maybe Lordship. Lordship, the petitioner is a landowner, and the petitioner is aggrieved by the order of the.
Just a minute. Yes.
May I please, my lord? My lord, the petitioner is landowner under the Raland area subdivision in the village of Lishayang village under Gauhati district. The petitioner is aggrieved by the order of the subdivisional customary court dated 10 December 2024 and the order issued by the head Dobashi District Customary Court, Deputy Commissioner Office, Woka. The fact of the case is that under the village, the Lisiang village, the petitioner is landowner. Under the IGGL gas pipeline, the petitioner's land, where the compensation, the issue is regarding compensation, where the land, where the pipeline, the IGGL pipeline covers 90% of the petitioners in the petitioner's land. But without the subdivisional customary court, Ralang division, without taking into proper perspectives the evidence, has decided that the compensation, 100%, out of the 100% of the compensation, 60% will go to the Leshang Village Council and 40% to the petitioner, where the petitioner stating that the pipeline, IGGL gas pipeline, falls under 90% of it is under his land. So compensation should be given as per his land, where the installation of the pipeline has been carried out. Lordship, as per the rules for the administration of justice and police in Nagaland, to assail an appeal, to prefer an appeal against the judgment of the head DB, District Customary Court. Appeal shall lie under Section 31 of the rules for the administration of justice and police in Nagaland, under 31. But Lordship, as of now, the judgment order dated 8/4/2022, passed in Civil Revision 5 of 2020. Lordship, that is page 22, Annexure 1. I may take Lordship to the operative portion. The operative portion is at page 41. Here, Lordship, in gist, where the appeal, as per the Section 31 of the Rules for the Administration of Justice and Police in Nagaland, an appeal shall lie from the decision of the Mausadar, Gambura, Chief Hetman of Kale, Dobashis, or other duly recognized village authority to the tribal court, whenever considered or otherwise, to the Deputy Commissioner or his assistant, Lordship. So, this issue is before a larger bench in Civil Revision 5 of 2020. The issue regarding an appeal should lie before the district second judge or the DC has not been decided yet.
It is still pending?
Still pending before the larger bench, division bench of this court. And in similar matters, this Honorable Court has in similar matters, in writ petitions, where the petitioners are aggrieved by the decision of the Gambura or the Debashis, which cannot be adjudicated either before the session judge or the DC, is pending, and this Honorable Court has been pleased enough to stay the impugned orders.
No, stay will be on its own merit. The question is to whom appeal lies.
To whom appeal lies.
That
now,
is the consideration.
Yes.
But grant of stay, for that, it has to be decided on its own merit.
Yes, definitely. For the time being. When the decision, when the larger bench of the Honorable Court in Civil Revision 5 of 2020 said that everything will come.
Now there are two conflicting judgment of single bench.
Exactly, Lord.
As of date.
Yes.
One is saying it lies before the Deputy
DC.
Commissioner. Other one is saying
before the district judge.
The district judge.
And that issue is
Therefore,
now,
okay, therefore you are not sure where to go.
yes.
And there,
So, Lordship, in similar matters, this Honorable Court was pleased to, for the interest of justice, this Honorable Court was pleased to list this matter along with the Civil Revision 5 of 2020 to its.
now what is the status?
Status is the impugned judgment was
Not
passed
of the
on
impugned
10
judgment,
December.
of the decision of Gauhati.
Till date, Lordship, till date, they have not implemented. So before this Honorable Court.
Who will give the compensation to you?
The compensation as of now, Lordship, as I've stated in my petition, the compensation is with the DC. Now the DC will give me, but till the decision of this civil revision is taken, it'll be kept like that.
Yes,
for the interest of justice. To
which one is the larger bench in which the matter is pending?
Lordship, page 41, before the division bench of this Honorable Court, it was sent to the.
Which is that division bench? What is the case?
Case number is Civil Revision 5 of 2020.
Civil Revision 5 of 2020 is the.
This is the main case. So still pending. The government of Nagaland is coming up with a civil rule to decide on the matter where the decision of the Dawashi should lie before the district session judge or the DC deputy commissioner. Lordship, in similar matters, in a writ petition 283 of 2024, Lordship, this Honorable Court was.
Where is the order? Yes, Mr. Tibafum.
Is to pass an order.
He's now seeking stay mainly on the ground that he do not know. He has no idea that where to go for appeals. Therefore, he has approached this court.
Yes, my lord, here I'm appealing for response number 1 to 3. And my lord, since the petitioner has implemented private respondent, at this.
Let us issue notice.
Yes, my lord.
Let the note without. It is not a case. Is there any urgency that DC will disburse the money?
Yes, Lordship. DC will disperse the compensation as per the impugned order that is dated 11 July 2025. That is why I have moved this unlisted, my lord. Lordship may be pleased to pass an order because demarcation of the land is yet to be conducted. So on verification, on proper verification, and on decision taken by the DC, the SDO, or the DC, or the land revenue on
demarcation of land has not yet been done.
Yes, that is why.
So
without going into all those, the SDO Ralan.
Whether the compensation quantum has been decided? No.
No, Lordship.
Then the question of disbursement does not arise now. It will take some time.
Yes,
that,
Lordship.
But time is enough to give notice to the private respondent.
Yes, my lord.
The interim relief would have been given if you could have shown any urgency. The urgency is not there.
Lordship.
Only decision has been taken.
Lordship.
We'll issue notice. Let the notice be served first on the private respondent.
Yes, my lord.
If it does not appear, we'll proceed with the interim. We'll make an observation.
Lordship, on the next date, Lordship. Lordship,
not on the next date, after service of notice on the private respondent.
Lordship, by the time if the compensation gets disbursed, then
who is the private respondent?
The private respondents are the district head Dawashi, district court, district customary court.
You can take steps for service of notice through Dasti mode also. Heard me.
At this stage, if this,
May I please, Your Lordship?
Yes.
My Lord, in the annexer, page number 55, the petitioner has already filed appeal before the Deputy Commissioner as per the record. So it shows that the appeal is pending before the DC, my Lord.
Lordship,
But
that
DC
appeal has been, Lordship, that appeal has been sent to the
district judge.
district judge, no, Lordship. Sent to the district customary court for fact finding and disposal of the case, Lordship. Lordship may come to page 83. That is a translated version of the judgment order. Lordship may come to page 83, Lordship. Page 83, annexure 8A. Page 83, annexure 8A, Lordship. Lordship, I've got it. I'll read the. In view of the ongoing and unresolved land issue between Lishayang Village Council and the parties of W. Yanthang, that is the petitioner, wherein the IGJ pipeline that stretch across Lishayang jurisdiction, the DC Wokha by order dated so and so, 25 directed the district customary court for fact finding and disposal of the case. And in response to DC letter dated district customary court issued a summon on both the parties on 19 June 2025 at 11 a.m. District Customary Court. Both parties submitted their documents, agreements, respectively, and their settlements were recorded. Accordingly, the court, upon verifying the documents and evidence, the findings are stated below. Lordship, I'm aggrieved that the Lordship may come to page 85, Lordship.
No, this 83 is the order of head Dobhashi.
Head Dobhashi, Lordship.
No. Where have you preferred appeal?
Lordship, I have preferred an appeal before the DC. The appeal is at page 55. But Lordship, the appeal has been referred to the district customary court. Power envisaged under Article 23, Section 23A. Lordship may peruse the rules for the administrative justice and police in Nagaland.
No, but then that submission of yours that you don't know where to go does not stand. You have chosen a forum.
This is under Lordship. This is under 29(1) of the rules for the appeal. The appeal is not under 31, Lordship.
What is the difference? Rules for
rules for administration of justice and police in Nagaland, Lordship.
What is the difference?
The Deputy Commissioner, Lordship, I may be allowed to read.
Yes.
The Deputy Commissioner and his assistant shall not ordinarily hear suits tribal by tribal courts, Mozamdars, Gomboras, chiefs, headmen of Khels, Dobashis, or other duly recognized village authorities, but they have a discretion to do so when they think right, and suits which under these rules the village authority and the tribal courts cannot try must be tried by a Deputy Commissioner or his assistants. A register of all suits tried by Deputy Commissioners and his assistants shall be kept in such form as the High Court shall direct. Lordship, surprisingly, Lordship, the appeal of the Gambura, the Dobashi, Lordship, head DB should be preferred under under Section 31 of the administration.
But you have yourself preferred it under 29.
Lordship. So, Lordship, now, as per the judgment and awaiting the verdict in Civil Revision 5 of 2020, this Honorable Court, Lordship, under 226, Lordship, has the power to adjudicate its matter. and for the interest of justice, stay the impugned orders and take along the writ petition along with the civil revision 2020, civil revision 5 for 2020, Lordship. This surprisingly, in my advertisements, I've made the submission that the appeal was endorsed to the DB. My lord, the DC endorsed appeal to the District Customary Court for fact-finding and disposed of the case. So without the court, without going into the facts, whether the land in question is of the petitioner or of the respondent 7 and 8. But arbitrarily, Lordship.
Where is the order of the Deputy Commissioner at page?
Deputy Commissioner.
Sending the...
Lordship, it is at page 83 only, Lordship. That is the translated.
83 is the order of the...
Order of the District Customary Court.
Yes.
But
where is the order of the Deputy Commissioner sending your case to? You are saying that your appeal has been forwarded to...
Lordship, it's reflected here in the order, Lordship. In view of the ongoing and unresolved land issue between Lisiang Village Council and the parties of the W. Kithan, wherein the IGGL pipeline that stretched across Lisiang jurisdiction, the DC Wokha by order dated so and so, 21st May 2025, directed. So this is the order. So we could not get the order, Lordship.
No, how it can be?
So it was endorsed. It was endorsed to the...
No. You are saying that you preferred an appeal against order of the Dobhashis, head Dobhashi, dated which order was impugned?
Appeal was against the order dated 10th December 2024.
Where is that order?
That order is at page 44, annexure 3. Lordship, translated copy is at page 45. Page 44 is the order, but the translated copy is at page 45.
Thereafter, the customary court passed order dated.
After the petitioner appealed before under section 29(1) the rules of our Administration of Justice in Nagaland.
And it referred the matter to.
And the DC referred the matter, endorsed the matter to the head GB. That is.
Head GB. And head GB also disposed of the matter.
Yes.
On 11 July 2025.
11 July 2025, Lordship.
You have not impugned this order.
No. 11 July, that's impugned, Lordship. That's at page 83. Translated copy is page 83.
So in this writ petition, so this is not a case where you are indecisive, where it should go. You have chosen a forum.
Yes.
Now you are against the order passed by that forum.
Lordship. And against this forum, appeals as per 31, section 31 of the rules for the Administration of Justice and Police in Nagaland, and appeals shall lie from the decision of the Mozada. This is the decision of the DB, head DB, head Dobashi, district head Dobashi.
Lie to?
Lordship.
The appeal lie under section 31 before which authority?
31. An appeal shall lie from the decision of the Mozadar, Gambura, chief, headman of Kales, Dobashis, or other duly recognized village authorities to the tribal court whenever constituted or otherwise to the deputy commissioner or his assistant. So the decision passed by the head DB as per rules for the administration of justice and police in Nagaland should be before the DC. But
it was the DC himself who had endorsed the matter. That too in an appeal.
Lordship. So we're aggrieved by that decision of the head DB. For the fact that now to challenge this order, either we should go to the deputy commissioner or the district executive judge.
Yes, Mr. Anit.
So that is my contention, Lordship.
My lord, my understanding is this petition should be heard differently because it should not club up with the civil revision. Because since the petitioner has already filed a bill before the DC, that means he has already used the forum. So in that pending civil revision is
in the appeal, DC had referred the matter
Yes,
again
my
to
lord.
head Dobhashi.
Yes, my lord.
Head Dobhashi has passed an order.
Yes.
He's saying that against the order of the head Dobhashi, he has no forum.
Yes, but he has no forum.
Because the law provides that it should go to DC under 31.
Yes. But since the issue as to where, since in the civil revision 5 of 2020 has been stated that
heard
either to go to the DC or the district executive judge,
Mr.
that still to be yet to be
Foseko
decided.
Learned counsel for the petitioner also heard Mr. E. Tibafon from Learned Government Council.
For respondent number 1, 2, and 3.
Is appearing for respondent number 1, 2, and 3. This writ petition under Article 226 of India has been filed by the petitioner, namely W. Kithan alias Wochumo Kithan, who is impugning the judgment and order dated judgment / order number capital DCC /CS /WK /2004-25 /01-04 /LD dated 11/7/2025 issued by the head Dobhashi District Customary Court. He is attached to Deputy Commissioner.
Lord, Deputy Commissioner Wokha.
Attached to the office of Deputy Commissioner Wokha. The Learned Counsel for the petitioner has submitted that the petitioner is a resident of
What should be landowner?
No, he has a plot. He has a plot of land in Leshan village under Wokha district, through which the IGGL pipeline. Where are the facts? What is IGGL? IGGL gas pipeline have been laid. He submits that entire portion of the land belonging to the petitioner has been affected, and the compensation from the compensation in that regard has been already deposited before the Deputy Commissioner Vokha. Stop. Learned Counsel for the petitioner further submits that why this 10 December 2024 decision was taken? Who referred the matter to this?
Lordship, on a complaint filed by the petitioner. Complaint,
You approached the court.
yes,
Why?
for disbursement and payment and disbursement of land compensation for laying gas pipe at Ralang subdivision before the SDO civil Ralang
The
subdivision.
petitioner on not getting the compensation for the use of his land for laying the pipeline of IGGL gas company had preferred a complaint before the SDO civil Ralan, and accordingly by order dated 10 December 2024, the Ralan Customary Court / Dubashi's Court had passed a judgment inter alia observing that the that 60% of compensation received from the company against use of the land of the petitioner would go to Lishan Village Council and 40% would go to the petitioner's staff. Learned Counsel for the petitioner has submitted that the petitioner preferred an appeal under Section 29 within bracket 1 of the Rules of Administration of Justice and Police in Nagaland before the Deputy Commissioner Vokha. However, to his surprise, the matter was referred again to the District Customary Court. Stop. He further submits that by the impugned order dated 11 June 2025.
11 July, Lordship.
11 July 2025. The district head Dobhashi Vokha had reiterated the decision of the earlier customary court and found the said order of the earlier said order dated 4/12/2024 as valid. Learned Counsel for the petitioner has submitted that the petitioner intends to prefer an appeal against the order dated
11 July 2025.
11 July 2025. However, the rules, under section 31 of the rules of administration of justice, administration of justice and police in Nagaland provides that the such an appeal would lie before the Deputy Commissioner. Stop. Learned Counsel for the petitioner has further submits that that a coordinate bench of this court has, while referring the matter to a larger bench, has observed that where is that judgment?
Lordship, that is at page 22 and each one.
Where is the operating part?
Operating part is at page 41.
Yeah, likha. Observe that the appeal in such cases would lie before the principal district and session judge. Learned counsel for the petitioner submits that the larger bench has been constituted. The matter is still the matter within bracket civil revision number
5 of 2020.
5 of 2020, comma, after it was referred to a larger bench, comma, is still pending before the said bench. And hence he submits that the petitioner is uncertain of the forum to which he should approach for grievance of his redressal. He submits that till the matter is, he submits that as the decision of disbursing 60% of the compensation allowance, compensation amount to the which village council?
Lishayan Village Council.
Lishayan Village Council, and 40% of the compensation amount to the present petitioner may be executed at any time. The impugn judgment, impugn order dated, which impugn
Page 44, Lordship. That is 10 December 2024.
impugn order dated 11/7/2025. 11/7/25.
Lordship, 10 December 2024 and 11/7/2025. I'm giving this both this letter. 10th December was by the subdivisional customary court.
10 December 2000, impugn judgment order number RLNDB (S) case number 17/2024 dated 10 December 2024, passed by the subdivisional customary court /DB's court, Ralan subdivision, Woka, as well as impugn judgment/order number DCC/WK/2004-25/01-04/LD dated 11/7/2025, passed by head DB District Customary Court, Woka, Office of the Deputy Commissioner Woka may be stayed during the pendency of the reference in Civil Division number 5/2020 before the larger bench. Stop. On the other hand, Mr. E. Tibafon has submitted that the petitioner has already availed his remedy of preferring an appeal against the judgment dated
10 December
10/12/2024 passed by the sub-divisional customary courts, as he has already preferred an appeal against the said order under section 29(1) of the Rules of Administration of Justice and Police in Nagaland before the Court of London, before the Court of Deputy Commissioner Woka. Hence, in this case, hence he submits that this case is not affected by pendency of the criminal revision, civil revision number 5 of 2020 before the larger bench. So, considering the submissions made by learned counsel for both sides, this court is inclined to issue notice in this case. Issue notice since Mr. E. Tibafom, learned counsel for learned government counsel, has appeared for
Respondent 1, 2, and 3.
Respondent number 1, 2, and 3. No formal notice need to be sent to the said respondent. However, the petitioner shall furnish requisite numbers of copies of the writ petition to the learned counsel for the learned government counsel within a period of within a period of 7 days from the date of this order. As regards other respondents, the petitioner is directed to take steps for issuance of notice on the issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order. Date of this order. Returnable after 4 weeks. Stop. Considering the submissions made by learned counsel for the petitioner, in the meanwhile, till returnable date, the impugn order dated 10/12/2024 passed by the Subdivisional Customary Court / DB's Court, Ralan Subdivision Woka, as well as order dated 11/7/2025 passed by Head Dobhashi District Customary Court in bearing number DCC/CS/WK/2004-25/01-04/LD shall remain suspended. Stop. Till next returnable date. List accordingly.
Much obliged.
For hearing, item number 21.
You are ready?
Lord,
this,
Because the screens are not placed properly.
my lord.
It is not very convenient for Lord.
First week of September.
We'll adjourn this matter to a date when the Railways Council may come physically.
First week of September, my lord.
Okay.
First or third. First or third.
Otherwise, how much time will you take?
Wait, an hour. Lord.
Okay, we don't have that much of time to do this. Heard Mr. Muazzamir, learned counsel for the petitioner.
9th.
Also heard Mr. E. Tiba from Learned Government Council appearing for respondent number
2, 3, 4, and 8.
2, 3, 4, and 8, as well as Mr. H. P. Gupta,
H. Gupta, my lord.
sorry, H. Gupta appearing through video conferencing for respondent number
Not all the respondents.
for all the remaining respondents,
1 and 5.
1 and 5.
Yes.
Well, due to this matter could not, the hearing of this matter could not be taken up today due to paucity of time. Hence, let this matter be listed in the first week of September on a date to be fixed by registry. Let registry fix date.
My lord.
Much better.
148 of 35 WBC 148 of 35. Thank you much.